today's meeting of the Chattanooga-Hamilton County Regional Planning Commission. A couple things I wanted to go over before we get started. First off, the Planning Commission has received this packet in the mail a little over a week ago, and they've had the opportunity to review it in advance of today's meeting. And so at times throughout the meeting, we do move pretty quickly. So make sure you've got a copy of the agenda there in front of you and you follow along. What I'll do is in each case, I'll read off the case number and the agenda item and the address and so on and so forth. And so if you're looking at the agenda there, you'll be able to tell where we're at. In each case, I'll ask if there's any opposition present. If you're here and you're in opposition and you wish to speak, make sure to raise your hand so that you could, so that I'll know that there's folks that are here in opposition that want to speak. And sometimes people don't necessarily think of themselves as opposition. They might have some questions or concerns. If that's the case, when I ask if there's opposition, make sure to raise your hand so that when the time comes, we'll know that you're here and you want to speak on a case. If we do have opposition to a case or we have a staff recommendation for denial, I'll ask staff to present the case that's included in our packet, the Planning Commission packet. After staff has presented the case, there'll be an opportunity for the Planning Commission to ask staff if they have any questions. After that time, the applicant will come up to the podium here on the right side of the room. And I'll ask that if you are the applicant, go ahead and come up while staff is presenting the case so that we can just make the most of our time and present your name, tell us your name and address for the record and the reason for the request. The applicant will have a total of 7 minutes to present their request. There will be some back and forth between the Planning Commission and the applicant. After that, the applicant will sit down and anybody who wishes to speak in opposition is welcome to speak. The total time allotted for opposition is 9 minutes, and we do stick very strictly to the 9 minutes for the total amount of time that's allotted to opposition. And so what I would ask is if you're here and you're in opposition and you want to speak, make sure to get out of your chair and line up on the right side of the room here behind the person at the microphone. So that way I can see if there's 15 people that want to speak and there's only 9 minutes, I can do some quick math and know that there's only 42.5 seconds per person, which is a problem. So what I would say is if you see a long line of people here and you have the opportunity to speak during that 9 minutes, make sure to tell the Planning Commission and staff something that we haven't already heard. Make sure that your comments are brief and to the point because we want to hear them, but we only have that 9 minutes. After that, opposition's had the opportunity to speak. Opposition will sit down and the applicant will come back up to the microphone and they'll have 2 minutes to respond. All the conversation that takes place today will be between the person at the microphone who we've recognized and the Planning Commission. So make sure to direct any of your questions to the Planning Commission or any of your comments to the Planning Commission. Please do not direct questions to the applicant or staff. With that, Mr. Schultz, one other thing. In most cases that we hear today, there will be, these cases will be on either the City Council agenda or the County Commission agenda. And I think that those dates are probably out there.
But they are. There's a little sheet in the back.
So make sure to follow along to see if these cases go on to City Council or County Commission so that you can attend those meetings as well if you'd like. So with that, we'll jump into the agenda. The first item on the agenda, item 1, is HCSD-24-29, and this is a final plat for lots 64, 65, 111 through 167, located at 1008 Birchwood Pike, and it has a staff recommendation to approve. Is there any opposition present? Second. We have a motion to approve, and it has been properly seconded. Is there any discussion? All in favor say aye. Aye. Any opposed? Motion carries. Next case on the agenda is item 2. It's HCSD-24-30, and this is a preliminary plat for Windy Ridge, lots 1 through 39, located at 0 Eldridge Road, and staff was recommended to deny the applicant's request for a preliminary plat here. Is there any opposition present? Okay. And is the applicant present? Thank you. Mr. Schultz?
Sure, Mr. Chairman, we also did receive some emails in opposition to this case for a preliminary plat. On the screen is the preliminary plat. It's for 39 lots off Eldridge Road up in the Birchwood Harrison community. Just as a reminder, Planning Commission action on plats is final. This does not go in front of the County Commission or City Council. The Planning Commission may deny a plat for any of the following reasons in the subregs: failure of the plat to conform to the standards set out in the subdivision regulations. Number two, approval of the plat would be detrimental to the public safety, health, and general welfare. And number three, approval of the plat would not be in the best interest of the local government. So there is reasons in the subregs to deny subdivision plats. Here's the overview, aerial view of the site. You can see the site's just on the left-hand side. Eldridge Road is sort of in the middle. This property is in the middle of Eldridge Road. If you go to the north or to the right of the screen on the Eldridge, it takes you to Birchwood Pike. If you go south on the Eldridge, that takes you to Birchwood Pike. Birchwood Pike's just on the right-hand side. Here's a closer view, zoomed-in view of the site. We'll talk about these two areas listed in white in a few minutes. To the north of the site, there's flooding concerns along Eldridge Road. And to the south of the site on Eldridge Road, there's concerns with a bridge that's weight restricted. We'll go through some images of Eldridge Road. These are two images of currently Eldridge Road. It's tar and chip, I believe. It's very narrow. Some places, I think it's like 10 foot wide along Eldridge Road. Some places it is a little wider, a little less, a lot of curbs and ditches along this road. You see on the screen those two pictures. Just another view of Eldridge Road. Here's a view of the bridge that I talked about a few minutes ago that's weight restricted. It's not very wide, but this is one bridge to the south, one access point to this proposed development. Here's a further view of that bridge just to the middle of the screen. You can see there's a sign on the right-hand side. It's weight restricted to 10 tons. This is another view of Eldridge Road. You see again, it's very narrow. It's tar and chip. You can see a lot of it's ditches on the left and right. Another view of Eldridge Road. Another view of Eldridge Road. Here's another view of Eldridge Road. You can see it clears out a little bit better in this location. Here's Eldridge Road. We're talking about in a few minutes. You see on the right-hand side and the left-hand side, this is the culvert or ditch where it floods. You can see there's standing water at this location. You can see the picture of the right and left of this picture. So the subdivision review team reviewed this preliminary plat. Both the Hamilton County Fire Marshal and the Hamilton County Highway Department recommend to deny this plat. There's public safety concerns pertaining to the access to this site. One, via the bridge to the south is weight restricted. That's the 10-ton limitation, so getting an ambulance or a fire truck or even construction vehicles at this location will be difficult on this bridge. And to the north, another access into this site is also, there's public safety concerns related to this culvert and it flooding. Sometimes it floods over the road. So the fire department in this area, which is Highway 58, has stated it would be difficult for them to get there in case of emergencies, just due to that bridge and the flooding concerns at this location. Here's another site view. You can see basically this is not in the floodway or flood hazard area where it floods, but you can see the stream that comes through there. It probably should be studied to see if it does. It is located in the floodplain floodway, but you can see the stream that comes through where this would flood. So Hamilton County Highway Department and Fire Marshal recommend to deny. Again, there's public safety concerns with approval due to the bridge at the south end and flooding to the north on the north end. Staff also feels approval of preliminary plat would be detrimental to the public safety, health, and general welfare. And approval of this plat would not be in the best interest of the local government. So staff recommends to deny this plat. The next case is a variance for road standard variances and creating lots less than 5 acres on a private road. Staff would recommend to deny that variance as well. But on the plat, we're recommending to deny.
Thank you, Mr. Schultz. And was there any additional information that we needed in regards to item 3 on the agenda? Because we'll hear opposition and the applicant's request.
Sure.
Both.
You're going through the variance request are one is to the Hamilton County subregs to have a road not meet county construction standards in terms of curb and gutter, but do more just ditches. Also, they're asking for relief to the 5-acre rule, allowing these lots to be anywhere from half an acre and up. The largest lot's 3 acres off Eldridge Road. These are really small lots on the private road.
Thank you. Mr. Price. Any questions for staff?
And while the applicant's coming up, we do have other folks from the fire marshal's office, if you'd like to hear from them in relation to the reasoning behind the denial.
Thank you.
Thank you. Mike Price, MAP Engineer, 7380 Applegate Lane. I do have a letter that I'd like to pass out to members of the Planning Commission. So this development has been one that has been proposed and had a lot of discussion over the last several years. As a matter of fact, there was a meeting that was held several years ago. Commissioner Highlander was in that meeting as well as members of the RPA staff, at which time it was determined that if a water main was run from Birchwood Pike to this development, and we provided potable water as well as fire flow protection, that we could do the subdivision. In the process, we then developed engineered plans. We went through the process, submitted those to Savannah Utility District, began the permitting process, submitted plans. We were then called to a meeting that was held at the engineering department at Hamilton County, at which time we basically had the rug pulled out under our feet from what had been agreed to previously. What was stated is what staff has stated here, is that there were concerns. All of those concerns had been discussed some 2 years ago. And it again had been determined that the appropriate action that we took was if we provided fire protection for this development, we would be good to go. In that discussion, it was discussed about the 2 points of access here along Edgemond Road. You do have a weight limit restricted bridge. We understand that. That's too costly for us as a developer to take care of. The other option coming from the northern side here on Eldridge Road is you have a section that floods. We did not deny that. What we propose is that we could pick that road up, raise it so it would no longer flood. We don't need anyone's property. We can handle that within the right of way. We even propose, hey, we'll do a TIF. You do a TIF, we'll fix the road from Edgemond Road or Eldridge Road all the way up to our development. The response was they had no interest in doing that whatsoever. So what I'm seeing here is a lack of cooperation as it relates to trying to find a solution here. Let me go further in the fact that there have been building permits issued directly across the street from this development. Now, we're saying you should not build this development because it's a safety issue, then nobody should be building on this stretch of road. If it's not safe for all of us, it can't be safe for one. So what we have here is some inconsistency as it relates to the way that the rules are being applied here. If it's not safe, don't issue any building permits. None. If it is, however, not an issue or an issue that can be resolved, then let's work to try to find a solution. We thought we had that with putting in a water main. We're still willing to looking at Eldridge Road on the northern side to fix it. What we need is the Planning Commission, as I see it at this point, to weigh in, because you're going to find not only this development, but others, they don't meet utopia. We don't have utopia. We have real world. You don't always meet 26 feet of pavement from the fire station all the way to the development. You don't have it. That's just real world. You don't always have the response times of what you're now saying that you have to have. But we also realize that there's portions of the county that if we apply these rules, then nobody should be building. If you're a private property owner and you own 20 acres someplace out in the northern end of the county, you shouldn't be issued a building permit for anything, not a barn, not a house. So how are these rules going to be applied? I think that's the greater question. How are you going to apply these moving forward? No building permits for anybody, or if you're planning a subdivision, then you get struck down in these situations. So I'm needing a little bit of clarity is what I'm asking for. Hopefully the Planning Commission can start that discussion to get that determined. But overall, if we fix the flooding issue and we provide a fire main, I grant you that the road is not wide. But I've seen low boys drive up down through there. And if a low boy can make it, I guarantee you a fire truck can. So again, we don't have utopia. We have situations where you simply will not meet every single regulation. But if there's fire service provided and the flooding issue is addressed, there's access that can be made. And we would ask that the county continue to uphold the agreement that had been reached several years ago. So if there's any questions, I'll be happy to answer those.
Thank you, Mr. Price. Are there any questions for the applicant? Commissioner Highlander.
Yeah, not really a question, more of a comment. And since Mr. Price brought my name up, when we had that meeting, and I do appreciate the meeting, it was a good meeting. The water main was a major concern. I also had concerns about the width of the road and the fact that the north end floods very badly. I've seen water, I've seen water 2 and 3 feet over that road. It said, and Brian said 10 feet. There are a couple of places it's 8 feet. People who live there have to pull over so they can drive by. I did speak with the fire marshal for Highway 58. He said we could not service it. We cannot get our fire truck or tanker truck up that road. But thank you.
Any other questions or comments for Mr. Price at the moment? All right, we'll hear from opposition. You'll have the opportunity to follow up. If you're here and you're in opposition, you wish to speak, please come on up.
My name is Mike Brooks. I'm with Hamilton County Fire Marshal's Office, 1644 South Seminole Drive, East Ridge. And what is earlier is in opposition is I talked to the chief of Highway 58 Fire Department, and he said that they will not use the north end, that they're going to somehow, I'm not sure if he meant on his bigger trucks, but use the bridge. And, you know, the weight limit on that is awful low. And that's the way they would probably come. It'll put the residents out of the 5 mile limit as far as travel distance, as far as their insurance. But he said that's the way they would go to get there because they feel more, you know, they're just not going to take their trucks on that narrow road up there, especially where, you know, it's been washed out and stuff like that. And with the fire marshal's office they're going to build a subdivision, but getting there is one of the main things. One of the things he emphasized, the chief, they are going to get there. They can't guarantee a timely, you know, how long it will take them to get there because they're going to have to go the long way. And with all the other things that are going on, you know, not sure if some of their very big trucks that would risk taking along with them.
Mike, if I may, I just want to make sure because obviously I've been involved in some of these conversations. And the process is for subdivision that meets the subdivision regulations to come through this process. But I do want to ask you a question relative to jurisdictional authority and plats, understanding that this is a venue to discuss public health, safety, welfare issues, which have been brought up by the fire chief. But at this point, there's no intention for the fire marshal's office to sign a plat relative to a subdivision development in this area.
No.
Thank you.
No. And talking about water mains, that would be one of the things, but the fire trucks have to get there. The firemen have to get there because we, you know, in the fire marshal's office, we want everybody out there to have the best chance at whatever emergency they have that somebody will show up and take care of them. Water mains are great, but, you know, we haven't signed anything or dealt with anything on that yet. Okay. Thank you.
Thank you.
Nathan Janeway, Director of Development Services for Hamilton County. I just want to clarify 2 things. One is that there was never any agreement in writing whether we would approve a plat or not. And the second point is that we did give an option to be able to move forward with the plat, and that's to bring either one end or the other end of the road up to fire code.
Thank you. Hey, the clock isn't working or got you. Thank you. We'll start it now. Thank you.
Hi, my name is Brandy Bales, and I've lived on Eldridge Road for almost 21 years. Safety is a huge concern for me, so much so that when my kids started school, a bus from Hamilton County would not come down the road. They said it was too dangerous. They said that we could meet them at the end of the road on either side. But when Hamilton County Department of Education came down through there, they said absolutely not. So it is a concern having more vehicles and big trucks on our road. That's all.
Thank you, ma'am.
Tony Allison, 13640 Elk Road. And I have pictures of the creek flooding. You may be able to see. It's not a potential that it will flood.
If you're at the, we can hear fine, but just make sure you pull that microphone all the way down too.
Kim Helton, 8618 Snow Hill Road. There's a big difference between issuing 1 or 2 building permits and approving a subdivision plat. And this is just phase 1. And there are many roads that go off of this subdivision plat. So there will be even more added to this in the future. And the road is not up to fire safety standards. It's not even up to Hamilton County road standards. It's a 1-lane road, and it was approved in 1924. That was a very long time ago. There have been no other resolutions for this road since 1924. And so there's questions about right-of-way and whether or not they even have the right-of-way to put this water line in. That's a big question that residents would like to know as well. Thank you.
My name is Shannon Dalton. I live off of Eldridge, actually one of the new neighborhoods that just got built. It's really not a neighborhood we built. My son, my brother, and I built homes back there. So I understand the point that he was making. If they can't get a permit, no one can. However, like the last lady said, 2 vehicles per household, 60 households, there's 120 cars going up and down that road. I have grandkids. We walk out there, and I just can't see the safety of for them going out there, and it's just a big concern. I just want to be here in opposition.
Good afternoon. Greg Vital, State Representative, and I live at 5724 Dogwood Drive in the vicinity of this neighborhood. We've welcomed many new neighbors up in this area over the last couple of years. I think they come for a special reason. The largest of lots, the rural feel of our community. We've been working with the Planning Commission to try to address those issues over the last several months, as you have been trying to address those issues across the county. I would just say the recommendations that the Planning Commission has suggested as reasons for denial are legitimate. They need to be considered. It is a safety hazard. Eldridge Road needs major redevelopment. The development, shrinking the lots from 5 acres to 3 acres down to a ½ acre, is inappropriate, not in keeping with the area. The incompatibility of this density at that location really doesn't lend itself to the community up there. And I would just say, follow the recommendation of the Planning Commission here. They spent a lot of time looking at this. If you've got any question, come visit. You'll see they've got the right recommendation. Thank you.
My name is Kathy Faulkner. I live at 5721 Island View Drive, Harrison, Tennessee, which is very close to this proposed development. And the only thing I have to add, because everyone's covered most of the major concerns, that bridge was built in 1938 that we keep talking about and seeing pictures of. It is a single lane bridge. In other words, 2 cars cannot pass on that. So I can't imagine construction vehicles, trucks, cement trucks trying to go across it. Several years ago, it was proposed that that bridge have some major repairs done. That has never been done. So the safety of it now is questionable. But if it starts having a lot of development in that area, even more and more traffic on it. And while Mr. Price says they'll make the other end safe and keep it from flooding, let's face it, that road is like a circle out to Birchwood Pike. People are going to use this bridge. They're going to go across it, and it is dangerous to not only the public, but any of the workers, the fire trucks, emergency vehicles. So I urge you to take that into consideration. Thank you.
Thank you. Mr. Price.
Again, I asked the question, if it's not safe for us, why is it safe for one more to build? What's the limit? If we broke this up into 5-acre tracts and we proposed 80 lots, and that's in conformance with the way the rest of the area is developed, 5 acres bigger, does that mean it's okay? Where's the number? I'm looking to the planning commission. I'm looking for staff. Someone give me a number. What is the number? I'm hearing ours is too much, but apparently it's not for others if they want to build out there. So what's the number?
Anything else, Mr. Price?
That should do it. Thank you.
Thank you. Councilman Ledford.
Thank you, Mr. Chairman. Brian, if this were today denied, is there a waiting period for reapplication?
No, it can come back next month.
Thank you very much. Thank you.
Actually, sorry, the following month. If I missed the deadline, it'll be January. Yes, there is no deadline like the zoning cases.
I do have a question, and this is not in any way, shape, or form a statement, but this probably is directed to RPA staff, but maybe the county as well. Mr. Price has asked the question of staff is recommended to deny this plat. It's for how many lots?
39 in this phase.
So 39 lots in phase one. What is the right answer in terms of the number of lots that would be approved based on what information? Because while I am not in any way, shape, or form siding with Mr. Price, or
right,
will I even likely vote on the case, but it is a legitimate question. If it were a plat for 2 lots, it would likely be approved. Is 5 too many, or how does staff or the county even answer that question?
I can't. That'd be a fire marshal perhaps question. Now,
but the fire marshal has indicated that they can't fight one fire.
And so if you do 5-acre tracts, in this case, in this particular property here, they're extending a road to utilities. That therefore would be a plat. We would probably still recommend denied, regardless of how many lots are on there.
But let me only add, and I'll kind of piggyback off what Brian said. I mean, individuals have private property rights in this state. The state gives individuals private property rights. What's not a by right is to subdivide property to meet Hamilton County subdivision regulations. Those subdivision regulations have certain requirements. One of them is public health, safety, welfare. It does give jurisdictional authorities to many of the individuals that would sign that to make sure that they're signing a plat that provides that health, safety, welfare. And again, to my question relative to the fire marshal, currently a plat relative to this area of Eldridge Road without some of the improvements that have been talked about, a plat would not be signed just based on that jurisdictional authority. And those are certain requirements or responsibilities that each jurisdictional authority has. So that would be my answer to that question. There are certain things you can do by right based on state law, by deed. You can also have a right to build on your property and come down and get a building permit from the jurisdictional authority. In the case that has been talked about with some of these individuals building on their personal private property, we issue building permits when they have appropriate access to a county public road, which they do in this case. There's not the same level, the same threshold of authority and responsibility relative to that, relative to signatures and a signature block on a plat.
That's very helpful. Thank you. Any other questions or comments?
I make a motion to deny.
Second. We have a motion to deny, and it has been properly seconded, and that's in regards to the preliminary plat. Is there any discussion on that motion? All in favor, say aye. Any opposed? Motion carries. And in regards to case item 3 on our agenda, HSDV-24-4, which is located at the same property, 0 Eldridge Road. What's the will of the commission? Second. We have a motion to deny. It has been properly seconded. Any discussion? All in favor say aye. Any opposed? Motion carries. Thank you. Next case on the agenda, item 4, is HCSD-24-31. It's located at Rogers Branch, lots 1 through 113, located at 9012 Rado Road, and it has a staff recommendation to approve. Is there any opposition present? And is the applicant present? All right, Mr. Schultz.
Yes, this is the final plat of called Rogers Branch subdivision, lots 1 through 113. Staff reviewed this with the correction, a few things coordinating with the street names of GIS, show on label the sign marquee. Ownership dedication certificate needs to be added, removed as these roads are private. With those changes, this plat does meet the requirements of subregs, and staff would recommend to approve as a final plat.
Thank you. Is the applicant present? Okay. Do you want to say anything? Okay. Ms. Helton.
Kim Helton, 8618 Snow Hill Road. This development received a notice of violation from TDEC a couple of weeks ago. They made a stream crossing that was not authorized by TDEC and did not have a permit to do so. So this subdivision plat is out of compliance with TDEC, as well as it says structural and non-structural EPSCs do not match the plans on file with the division. So the construction of ponds near outfall 1 and 2 appear to have impacted existing sinkholes at these locations. Ponds appear to have been connected with on-site modifications to structural design, and check dams are absent, silt fence, it goes on. Unauthorized stream alteration, and as of this morning, they did not have a permit issued for that. So since this is out of compliance with TDEC and Hamilton County Water Quality Department rules and regulations, we feel that this should be denied right now until it comes into compliance. Thank you.
Thank you, Mike Price, MAP engineer. So we have the necessary permits from TDEC. We also have the permits from Hamilton County Water Quality. There was a notice of violation that was issued as it relates to the tie-in at the creek, which we have submitted a response back to TDEC for corrections to be made by the contractor. But as far as I know, we're in compliance and we meet all the subdivision requirements for this plat anyway. So hopefully this would be one that can be approved. Any questions? Happy to answer.
Thank you, Mr. Price. Any questions? What's the will of the commission? We have a motion to approve and it has been seconded. Any discussion? All in favor say aye. Aye. Any opposed? Motion carries. Next case on the agenda is item 5, HCSD-24-32, and this is preliminary plat for Nature Trail, lots 129 through 140, located at 528 Nature Trail, and staff is recommended to approve this. Is there any opposition present?
Second.
We have a motion to approve, and it has been properly seconded. Any discussion? All in favor say aye.
Aye.
Any opposed? Motion carries. Thank you. Next case is item 6, case SDP-24-42, and this is final plat for lots 1 through 95, located at 8155 East Brainerd Road, and staff is recommended to approve. Is there any opposition present?
Second.
We have a motion to approve, and it has been properly seconded. Any discussion? All in favor say aye.
Aye.
Any opposed? Motion carries. Next item is SDP-24-43. This is item 7 on our agenda. It's preliminary plat for Stanford Village. This is for phase 1, lots 1 through 86, located at 7518 Stanford Gap Road, and staff is recommended to approve this preliminary plat. Is there any opposition present?
Second.
We have a motion to approve, and it has been properly seconded. Any discussion? All in favor say aye.
Aye.
Any opposed? Motion carries. Item 8 on our agenda is SDP-24-44, and this is final plat for Riverton Farms, lots 1 through 38, located at 1100 Lupton Drive. And staff is recommended to deny the applicant's request for final plat. Is there any opposition present? Is the applicant present? And Mr. Schultz?
Yeah, Mr. Chairman, when staff wrote the staff report, we did not recommend approval at that time. As of Friday, this is going to be bonded, or actually a letter of credit issued with the city of Chattanooga and some of those departments. That's been worked out, so we recommend to approve this plat with a condition. Approve the condition that the development agreement and letter of credit be provided as agreed upon before any building permits may be approved. So we'd recommend approval subject to that condition.
Okay. Thank you. I have a question about that, but so does Mr. Lehman. So I'm just trying to understand process. So how would this final plat be different than other final plats where the infrastructure is not finished and it's awaiting signatures?
That's good. It is not, it's not any different in that regard. The only difference in this regard, none of the infrastructure is actually in place. It's a greenfield development. So they're asking for 100% bond or letter of credit on this property. Typically when they come in, some of the infrastructure is in place. The road bed's down, graded. It's almost 80% constructed. This is not. It's 100% greenfield. This is different in that regard. So from Public Works, in terms of Transportation Department, wastewater, there's some sewer easement that needs to be abandoned. So they were holding it up, make sure that development agreement, it's something staff cannot approve in terms of letter of credits. That needs to come from some other departments. They've been trying to work those out.
But if an applicant, I'm just wanting to understand process. If an applicant comes in with a preliminary plat and it's greenfield and a final plat and it's greenfield, it's not that uncommon for us to approve a final plat.
It's not.
Letter of credit.
It's not. But I think they're willing to go as of today, get this thing signed, recorded tomorrow, start selling lots.
Gotcha.
That is a
So
little
the, so the
difference.
condition that's being added, what was that again?
The conditions being added is the development agreement and letter of credit be provided. That's the city as agreed upon before any building permits may be approved. In this case, this plat could, in theory, get recorded tomorrow. They could sell lots. Someone would own that lot and could go get a building permit for something that doesn't exist. There's no right of ways there. There's no sewer there. So that's why the city's trying to protect themselves by saying this needs to be in place before any building permits are issued. Yes. This gives them the ability as of tomorrow to start selling lots.
Okay. Mr. Lehman.
Not, I do have a question though, since you brought that up. And just relative to, I know this is City of Chattanooga, we don't typically bond projects to start. Typically you bond them potentially to finish, and then you don't sign the plat until you have that final bond to finish. Like this one sounds like it's a bond to start. They haven't started. I guess my question is, can we condition plats with that, or are we just making a statement? Okay.
Okay. And I talked to the city engineer this morning. He's fine. It's not ideal, but he's fine with the bond the way it is.
Okay. My only other question is what compels him to sign without a bond, even with action from this?
He wouldn't sign it if there's no bond or letter of credit in place.
So they couldn't sell plats. They couldn't sell lots tomorrow anyway. But
you can only sell the lots once the plat's recorded.
So then why do we have to have the condition?
I think the city's just trying to protect themselves, because once that lot is sold, someone could go to LDO tomorrow and ask for a building permit.
Right. There's
not going to be any road there. This is a greenfield development. There's nothing there.
I think the answer is that the city, I think, feels more comfortable having this condition relative to an approval from this body that then would just give them cover to allow them not to finalize any plats until that bond's in place.
And you're right. It'd be different if there was something there in terms of the infrastructure. There's nothing there on this. It's 100% bond or letter of credit build out, which is different for us. We don't issue, RPA doesn't issue or even involved in letters of credit. That all comes from a different department.
So if we can bond, I'm fine. I mean, if we can condition plats, I'm fine with recommending approval of the final plat with the condition that was stated relative to the bond.
And I believe the applicant, they can speak. I think they're good with that condition, the way it's.
Letter of credit.
And I did see the numbers. There's a number. I think their engineering firm supplied the city with a number and a 25% contingency cost to that.
Hannah Claire Bogus, Chambliss Bonner, and Stokeville. Happy to answer any questions, Councilman Ledford.
The question is, who's handling this on the city side? Is this the city attorney or Bill Payne?
Yes, we've been working. The city attorney has looked to its development departments to confirm that they are fine with the plat and to approve the letter of credit amount with respect to the amount of infrastructure that's being put in. Once Mr. Noblet got that approval, he has approved the development agreement. So it's technically the city attorney, according to the statute, that signs off on the bond itself.
Okay. With that confirmation, I would like to defer actually to Mr. Anderson. I think he might be able to shed a little more on this.
Mr. Anderson.
I really just have a question because we've met on site several times. We, being the Kelly administration, has met on site several times with the developers, and I just want to make sure that approval of this plat does not change the agreement we already have to have connectivity from one side to the other to extend the Riverwalk.
That is correct, although that is addressed in a separate easement agreement. But yes, that is correct.
Excellent. Thank you.
Sure, I'll stand on myself.
So we have a motion and second. Any further discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries. Thank you all.
Thank you.
So who chaired last month when I was out?
They said it was the best chair they'd ever had.
So does that mean you pick up and cover these three cases of old business?
Oh, yeah.
Okay. All right. First item under old business is case 2024-0144, and this is located at some unaddressed property in the 300 block of Browns Ferry Road, and it has a staff recommendation to approve with conditions. Is there any opposition present?
And Mr. Chairman, we did receive a lot of emails in opposition, and I believe talking to the applicant, they wish to withdraw this case.
Is the applicant present? And is that indeed the case?
Move to withdraw.
We have a motion to allow the applicant to withdraw, and it has been properly seconded. Any discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries. Does opposition wish to say anything? You did come here. Mr. Henderson, did you want to say anything? Okay, thank you. Item 2 is a mandatory referral 2024-0156, and this is located at an unaddressed property at 300 block of Ann Street, and it's for right-of-way closure, and staff is recommended to approve. Is there any opposition present?
Mr. Chairman, there was some opposition last month and emails in opposition, but I did receive right before this meeting an email from the neighborhood president that I guess they had a neighborhood meeting a couple nights ago, and I think they now are in agreement for supporting this abandonment, I believe.
I'm Diane O'Sullivan, representing the North Chattanooga Neighborhood Association, and
Can you state your name and or your address for the record?
Oh, I'm sorry, 818 Liberty Street.
Thank you.
After the meeting last month that I spoke at, we were able to meet with Zeka Ferraz from the Chattanooga Engineering Group to learn more about the plans. Appreciate their time on that, about that Ann Street abandonment. And he shared that they, with the abandonment of Ann, their Green Tech plans to only build single family homes fronting Franklin, which is 7 instead of the 14 that was originally planned for. That would have required that T-shaped street that didn't go along with fire safety code. So we asked Mr. Faraz to communicate to Green Tech. We haven't been able to meet with Green Tech to see that the remaining land that will be on the steep slope behind the homes be turned into a conservation easement through Mr. Faraz. We have received a commitment from Green Tech to place a conservation easement on the back half of the property in question, and then our neighborhood association president has submitted that email correspondence in the hopes that Green Tech's commitment to the conservation easement will be included in the public record. I have a printout of that email correspondence. It sounds like you may have already received it. If you'd like a copy, with this change in the development plans for Green Tech, hopefully we're putting that into an easement, conservation easement. We no longer oppose the abandonment of Ann Street. We believe that Green Tech's commitment to placing a conservation easement on a portion of this property will be a positive development for the neighborhood. We also hope that Green Tech will be willing to work with the neighborhood association and the city to connect this conserved space with the neighboring city of Chattanooga Park, the Sylvan Park Bird Sanctuary. Thank you.
Thank you. We have a motion to approve, and it has been seconded. Any discussion? I don't know that we could condition it with a private agreement, subject to a private agreement between the developer and the neighborhood. Any other discussion? All in favor, say aye. Any opposed?
Abstain.
Motion carries. Next case on the agenda is under old business. Item 3 is case 2024-0159. And this is located at 3511 Parkway Drive and 3745 Bonnie Oaks Drive. And it's an application to rezone from R1 to RN-1-3. And staff has recommended to deny the applicant's request. Is there any opposition present? All right. And is the applicant present? All right. Mr. Schultz.
This was deferred last month, I think, due to opposition. This is a rezoning request from R1 to RN-13 residential neighborhood zone for 3,000 square foot lots. Proposed use is single unit detached. Its number of acres is 5.15. Number of units proposed is 25, and that's a density of 5 dwelling units per acre. Just looking at the zoning map, it's all R1 currently. During the equivalency mapping of this property, it will go to the RN-16, which is a 6,000 square foot lot size. There's been no zoning history for this site. There is no other RN-13 zone property near this site, or by that I mean the 3,000 square foot lot size. It's located at 3511 Parkway Drive. Single unit detached abutting this property to the north, south, east, and west. Here's a view of the site from Parkway Drive. This is a site from Bonnie Oaks. This is southwest of the site at Parkway Drive and Bonnie Oaks. This is west of the site, again, another single family dwelling. This is a single unit detached dwelling on Parkway Drive. This property is in a historic river to ridge plan, was adopted in 2020. The plan recommendation is suburban residential. Here's a closer view of what that place type recommendation is, which is again suburban residential, which is single family large lot development. Here's a view of the site plan submitted with a request. One entrance in, 25 lots. The request is not compatible with adjacent development form and the Area 3 plan recommendations. Again, the RN-13 zone allows a 3,000 square foot lot size and 15-foot front setback and 25 feet of lot frontage. There are no other 3,000 square foot lots in the immediate vicinity of this site. Again, the property will be equivalency mapped to RN-16, which is 6,000 square foot, 25-foot front setback, and a 5-foot side and a 55-foot lot frontage, which is more compatible with adjacent residential neighborhood. The equivalency mapping of RN-16 is more appropriate at this location, so staff recommended to deny this request.
Thank you, Mr. Schultz.
Good afternoon. My name is Alan Jones of Stone Creek Consulting, 1112 Wilmouth Road in Dunlap, Tennessee. So a quick little history on this site. So back in May, we were actually originally looking at rezoning this with an R1 PUD. But at the time for our May submittal, we only had 4.98 acres. So we were actually working with the property owner that's if you're looking at page right, who the property owner there at Bonnie Oaks Drive. He had a weird backyard. So the developer who owns this property went and talked with him. They did some property swapping to provide a better backyard for that property, and that gave us the 5.02 acres we needed for a PUD. By the time we got those arrangements in place, we were looking at a June submittal. In June, the city council decided to put a moratorium on rezoning requests so we could see how the new zoning was going to shake out. Once we kind of saw what the new zoning was going to be, this is going to be slated for RN-16 with the December mapping and zoning, new zoning coming out. But PUDs are not recommended or not encouraged with the new zoning ordinance. So we started looking at other tools and how can we proceed with the same intent of a PUD, which, the intent of the PUD is to help preserve open space. So we looked at the RN13. The R13, if this was a straight R13, I would agree this would be out of context and not appropriate for this site. Two conditions that we would like to place on this condition or on this rezone request is to limit it to 25 lots or 5 units an acre, and also set the minimum lot width to 40 feet. That kind of puts it in line with more of the traditional PUD that we're not, that we're getting away from. If you look at the exhibit that's on the screen right now, that's what we can do with an RN16 is 25 lots. So we can still achieve 25 lots with the RN16. The concern with this site is it's going to require a lot more grading and clearing, especially kind of the front entrance on the bottom left-hand corner as you enter into Battery Heights neighborhood. I did meet with the neighborhood association last month. Thought it was a good meeting, kind of going over some of these details of what's the difference between RN16, the difference with RN13 with the conditions that both options are providing 25 lots. So either direction, the developer is going to be able to move forward with 25 lots. Whether we use the RN16 and we have to do a whole lot more grading and clearing and site work to get it to get this project built, or if we look at the RN13 with conditions of the 40-foot wide minimum lot size. Brian, if you wouldn't mind, show the other exhibit. So this is the same subdivision layout with an RN13, which does preserve that lower left-hand corner section of the site to be either left undisturbed or left for open space. In addition, after the neighborhood meeting, the city or the neighborhood association did send me about 32 questions. So I did send them a detailed 4.5-page response to a lot of the questions. And I want to highlight just a few of them. One of the questions was, why do you feel RN13 is necessary for this project? This is necessary so we can intentionally leave portions of the site undisturbed or undeveloped. With the RN16, we will gain, with the new zoning, we can already develop 25 lots, but we will disturb a whole lot more land with this disturbance. The main purpose is preserving the undeveloped land and to minimize working in the steeper slope areas and preserve the natural area as best as possible near the entrance to Battery Heights. In addition, there was a question and concern with traffic. The question was, how is the traffic going to impact this site? This development is going to be able to provide 25 new single-family homes. If you look through the historic Battery Heights subdivision that's already in place, there's 50 undeveloped lots currently in their subdivision or in their neighborhood association. So this is only half of what they already have that can be built out in the coming future. 25 homes is not a huge impact. If you look at the city requirements for a traffic study, it's 200 homes. So, from a threshold standpoint, this is yes, it's a big development for a community that's not seen a lot of development in recent years. But 25 is not a huge increase. But I do just want to touch that, 25 lots is what can be done with the RN16. And if this does get denied, that is how the developer would like to proceed. But we are trying to be good neighbors, they're trying to be a good developer by preserving the open space there on the front entrance to the Battery Heights subdivision. I'll leave it with any questions.
I would just ask one question, then we've got one from Councilman Ledford. So in this RN16 site plan that we're looking at right now, there's lots that are on Bunny Oaks Drive.
That's correct.
It looks like there would be 3 of those that wouldn't have any frontage other than Bunny Oaks Drive. I'm assuming those would be accessed off Bunny Oaks.
3 would be off. The 3 would have to be off Bunny Oaks, but more than likely the 5 to the left of that, or the 5 to the left, would either be, depending on how you do. That's where the steep slope is on those 5 lots right there. The better access is off of Bunny Oaks because that you have more space on the low side of the site and just do some slope retainage on the back side. You could have those accessed from the internal new road, but it would be more than likely having access off of Bunny Oaks.
So, and then in your, in that one there, all of them are accessed off of the new road?
That is correct.
None of them off Bunny Oaks?
That is correct.
Okay, thank you. Councilman Ledford.
Thank you, Mr. Chair. Yes. I can read the topo lines, so I see where your steep slopes are.
Right.
And we have the steep slope vegetation component, obviously, in the city.
Right.
How are you 100% certain that you're going to be able to develop those parcels?
Yes. So, we've looked at the steep slopes. We're going to be mostly staying out of them, but if we're in RN16, we'll stay out of most of them. It's just the rears of the lots that we have those steep slopes. And so the buildable area is staying out of those steep slopes. There might be some stability we'll have to do, but then there is a revegetation process we'd have to go through with that steep slope ordinance.
The second part is with the adoption RN13, and this conversation will continue at council, as we've already flagged it with RPA. Introducing that would obviously set a precedent, and you've mentioned there are 50 other lots in Battery Heights that this would now set a precedence for.
The 50 lots are small lots.
Yep.
But the precedent is,
but probably able to subdivide if you could maybe get into that. But my question is leaning more towards you indicated that RPA, we've abandoned the PUD process, or we don't want to do it anymore.
Mm-hmm.
Is that in the PUD process, there are safeguards, there are amenities and factors, parks and spaces and things that are built in, and obviously tying a site plan to which we cannot tie here.
Correct.
And those are assurances to the public that, quite frankly, I think are useful still.
Mm-hmm.
And I'm just wondering why do we not want to try to do that? Like, for example, that whole corner, if you were to able to build 25 in a PUD or in 16, you obviously have that standard set.
Right.
And we're going to talk about that standard here in a few minutes on some other cases in my district. Why wouldn't we want to go through that extra effort to maybe put that corner into a conservation easement so it's not developed, it's protected?
Yeah. Yeah. And
that question is to you. Why not go for the PUD?
I was recommended by staff to not pursue a PUD. That was why. So we decided not to pursue the PUD. Now, putting this in a conservation easement, the developer has no problems with that, because if you're capped at 25 lots, you can't put a home here anyways. So he has no issues of putting that into a conservation easement.
And obviously that would be a private agreement.
Correct.
Not fortified here at this.
Correct. And if this does, move forward to city council, or we'll move forward to city council, we can work with Councilman Coonrod and look at having get the acreage of this open space and say, hey, we're going to have X amount of acreage of open space as a part of this subdivision development.
My point is, Alan, and I'm sorry you have to be the first one up to take the brunt of this, is that we are going to abandon safeguards to the public for the sake of density when we could achieve the same goal. And I want to make sure that we're not abandoning the PUD process and those safeguards.
Right.
And we will, like I said, we will be having those conversations moving forward, maybe even some guardrails.
Yeah, and I think that's appropriate. And also last month, it's interesting, last month there was a case after this one went up, and it was a very similar approach. The applicant was looking at a PUD originally, and this board approved the RN13 with a 5-acre density cap with that same intention. So we do want to be mindful of how we move forward with this new territory that we're looking into.
Agreed. Thank you. Thank you, Chairman.
Mr. Berg, I just have one quick question. Have you looked at RN15 at all? It's kind of a happy medium.
We did. The issue is RN15 it's not even the lot size that the developer is concerned with, it's the lot width. If you look at the the new zoning tools is RN16, 5, and then down to 3. So we go 55, 50, and then a huge jump down to 25. So there's not a middle ground as far as, if you look at a lot of the PUDs that were developed over the past 2 or 3 years and approved, you're looking at a lot of 38, 42, 45 foot wide whatlets. And that's been approved, hands down for the past 2 years, no issues. But now we go from 50 to 25, and there's no middle ground. So we're trying to figure out a way to get to that middle ground with the new tools that are in front of us.
There's some folks here in opposition. Yeah. We'll give them an opportunity to speak. Is this everybody that wants to speak in opposition on this case? Because I saw more hands go up. If you wish to speak, come on up now. Make sure to state your name and address for the record.
Hi, Sheena Benavente, 4007 Countryside Drive. I brought my computer because I don't have a printer. All right, so thanks for allowing me to speak on behalf of Battery Heights Neighborhood Association. So after careful research, consultation with some experts and a lot of conversations with some very helpful people. We have to stand in opposition of the rezoning for 3511 Parkway, and that actually, short groups, that actually has a lot to do with some of the topics that were just brought up just now. The decision wasn't made lightly. We have a lot to lose here, like as a community, with this property. We reviewed both those proposals, the two proposals from Stone Creek Consultancy, and we sought clarification from Alan Jones. We engaged with the RPA staff, a ton of research, neighborhood meetings, fully engaged. And the more we learned, the more it became clear that rezoning right now is not the right choice for our neighborhood. Actually, I don't know that it's the right choice for the city at this point. And it just causes a very dangerous precedent for Battery Heights. East Chattanooga specifically is vulnerable. And this promise of being a scenic city with the precedence of allowing this RN13. So just to have a little bit behind the scenes, because Battery Heights is relatively unknown. It's a historic neighborhood. It's extremely diverse, working class, tightly knit community. We're in East Chattanooga, sort of in a lesser known area of Missionary Ridge, sort of at the foot and then back up. Our homes mostly sit with old growth, century-old oaks and pines, dramatic slopes, and very large lots. So families typically buy there because there's still affordability there, natural beauty, and it has a really engaged community. A lot of who are here and many who didn't get to make it because of the time. So we have a really proud history too. We have like a role in playing a pivotal role in the Civil War in Missionary Ridge. That was part of it. I think the biggest thing for us is that Battery Heights is really vulnerable with this new zoning code in its infancy. It's because it's one of the last relatively affordable neighborhoods to buy property, to buy land in the city. And it's like, it puts it in a specific situation with this new zoning to be kind of changed radically before the kinks are worked out with this new zoning code. And the proposal would radically change the face of the neighborhood. So specifically about 3511 Parkway Drive, it's heavily sloped, like drop-offs. I'd be shocked if it could be entirely developed, but I trust the threat. It actually is long. Can you pull the picture up? Was it Brian? Do you mind pulling up that picture of the development proposal? So right now it's like the main keystone property along Bonnie Oak. So it's at our entrance, right where the pillars are. And it's like kind of really wooded, really sort of like almost like a little bit of a nature preserve. There was one house there before. Tragically, the property was lost due to a fire. And that was a devastating community tragedy. I do want to be clear, and we talked about this a lot, is that we are not against like development. We know it's what's coming our way. We realize that growth is potential and we want to see that happen, but it needs to be thoughtful growth and it needs to respect the community's history, the landscape, and its existing people. One thing that really had me concerned through this process, outside of just the losing the character of the neighborhood, concerns about traffic, safety, like entering, exit, like making a subdivision within an existing subdivision, all big concerns we had, was just sort of the approach to this this application, this proposal, because there was the RN13 and there was RN16, and they were both proposed. RN13 alleged to keep some area natural, but there was no definitive commitments and there was no conditions. There was nobody saying, hey, this is how we go through the process of making sure that that promise is kept. This is the process. This is what you can do. This is what we will give you. It was more a polite threat that if we do not rezone, that we will lose the natural beauty of our interests and the character of our neighborhood. Not exactly a great way to start discussions is to feel like you're like, oh, if we don't rezone, we lose everything. I mean, I understand that it's by rights what's possible, but it's not right. Anyways, I digress. But we did ask a lot of questions about traffic, community privacy, alternative options. There was a lot of concerns about entering and exiting Battery Heights, the actual like neighborhood. We have these historic pillars there on a stone wall. Things about flooding, stormwater infrastructure. We were thorough in our massive questionnaire.
Ma'am.
Yes.
Ma'am, this gentleman behind you, I think wants to speak, and there's only
Mr.
3
Logan?
minutes left.
Okay, stay there, Mr. Logan. Okay, sorry. How much time do I have? Great. So unfortunately, it felt like our concerns were minimized or evaded politely, but there was fluctuating answers on whether there'd be an HOA or not an HOA. The community space would be private. It might be public. It could be sold to a homeowner. There was just no real commitment. And then also our concerns is that Mr. Jones's only job right now is to get it rezoned. And then once it's rezoned, there's no person after that we have is accountable for it. Currently, the LLC is anonymous, and they have a phone number missing a digit and an address that leads to a UPS with no personal box. There's no contact person there. It feels very opaque. So currently, there's no protections for Battery Heights with the new zoning, things like green space, slopes, tree canopies, infrastructures. And we don't want Battery Heights to become the first casualty or an example of harm for unchecked development when these safeguards aren't up yet. So while we have the RN13 and we understand the intention here, it's sloped, it's probably expensive to develop, it's better to just like give them something. I do feel like it opens up precedent for the rest of the neighborhood, and that really concerns us because right now there's no safeguards. There's nothing that says that the next person, the next developer is going to have those same considerations, and it's concerning. So we're thinking about long-term Battery Heights protecting. So it's tragic we would lose our entrance. It's tragic. And we don't not want anything there. We don't want that either. But this currently the way it's set up doesn't allow us to make those decisions. We have to sacrifice one for the other. It's really unfortunate. If the city of Chattanooga aspires to be a national park city, we need to start protecting all neighborhoods, especially vulnerable neighborhoods like East Chattanooga that lack accessible green spaces. Currently, there are no plans. I think even maybe like there's concepts for 10-year for accessible green spaces, but they don't have them now. So our yards with old growth are our green spaces. Our neighbors' yards are those spaces. So we're hoping for future developments, there will be more transparency and collaboration, protections, and considerations for things like infrastructure, safety, and just like how we can like build with like a scalpel and not like a shovel. Like, let's be intentional. I'm sorry for the time, Mr. Logan. Oh, look at that. Amazing. Oh, that's my community. Sorry. Is there any questions?
Councilman Ledford.
Sheena, thank you. That was from the heart. I appreciate that very much. You have done your research. One of the issues, and I think staff actually got this right. I think they nailed the head, and we need to be careful with this new 3. To abandon the PUD and the safeguards put in place, that's something we're going to be talking about at council, is exactly what this case is presenting to us. It's not just the density, it's all the good for density and none of the good for the community. And that's something that I'm concerned about. But my next question to you, though, is also this, and I've asked this many times in the years I've been up here. If it will go to RN16 by right, are you and the neighborhood willing to accept that? And whatever comes with that by right. This property rights has been a very strong pointed comment up here. I just want to make sure that in the spirit of compromise, I actually really appreciate the RM15 being presented. It's something you'll probably hear shortly. I think it's a good compromise, but I'm not getting that from the applicant unless they mention it in the 2-minute rebuttal. But are you willing to accept what will be by right?
We don't accept it
But
at
it
all.
is-
I
but
mean,
it
we,
is by right.
we understand it's by right. We understand it's the law.
Sure.
But no, we do not accept that. We
Okay.
do not accept that a new zoning code creates an opportunity for us to have to choose to not. And that we gave a questionnaire that allowed a lot of questions to be like, hey, where can you, like, can we do another road? Like, well, what is this? Like, is it an HOA? Will you send it to preserve? We gave opportunities for that, but we didn't hear any. So, I mean, it sounds like we voted, and it's sad because of how this is. Like, we know that this could happen. We know that this could happen, that they could clear cut the whole thing, use the entrance, the pillared entrance. We don't even know for sure if our pillars are part of that property or not. I can't get a straight answer. I mean, it was from the very beginning. It was, hey, which child do you want to turn over? That it feels very unfair. Do I accept it? Absolutely not. Do we accept it? Absolutely not. Do we know it's the law? Yes.
Okay. That was my question.
Well, thank you.
Thank you. All right. Thank you very much.
Any other questions? Thank you.
Thank you.
So to kind of touch on some of the comments, but I think the overarching idea of that this will set a precedent. Every site's unique, and that's been stated, for a lot of cases. Every site's unique. I don't like the idea that this was received as a threat, that they're just going to build the 25 lots in the RN16. That was a response to the developers trying to do the right thing as far as how to develop this property while maintaining and preserving the entrance of the neighborhood and preserving some of the steep slopes on site. Unfortunately, the RN1 PUD process was not available after June. Now, is an RN16 PUD something that the city and planning commission is willing to consider? Then that's something I think the developer would be more than happy to look at if that avoids the whole RN13 discussion. Because I do understand that RN13 with no restrictions is not appropriate for this site. But if you put in conditional zoning with a 40-foot wide lot width and with 25 lot max, to me, an RN13 with conditions is appropriate, given the context of this particular site.
Did you have a question for Seth?
Felt like there was one being asked. RN16 PUD, is it off the table?
No, there's a PUD. It's not an RN16 PUD. You have RN16 is the zone. You always come back in for a PUD
overlay,
and the council, through their review, can set different lot sizes and uses, but that's different from the RN16, but it has to go through that process.
Understood.
So that didn't go away. We still have the PUD. It's more difficult now.
Well, and it should be.
Yes.
Honestly, quite frankly, we were seeing it used as a density tool for many years, and strictly that. So I applaud that. But it's laid out in front of us that PUD is no longer even an option on the table, and I'm trying to gain clarity that PUD is an option.
PUD is an option. It's still there. But I think I'll speak on staff. I think we prefer that option instead of putting conditions on an underlying zone. That's the whole purpose of the zoning code, is move away from conditional zoning. And we're going down that route already.
Mr. Payne.
Yeah, I just have a question with staff. I guess the first bullet is the request is not compatible with the adjacent development form and Area 3 plan. I mean, but he can do 25 lots by right now. Is it? I mean, what makes it not compatible as opposed to what he can do right now by right being compatible?
But right now, he wouldn't be submitting a zoning case. He claims he can do what that's on the screen now is these lots meeting 6,000 square foot and 55-foot lots.
That's what I'm saying. If he can do it right now versus setting aside that green space, I guess am I asking which is more compatible?
The RN16. RN13 creates 3,000 square foot lots. You look at all those lots in this area, They're at least 7,500 square foot and larger.
Even, but I eat with the consideration that the whole piece of property goes instead of leaving green space.
Yeah, regardless of this, you go to the left of this screen, you go back to the aerial view. I'll show it. All those lots to the left and to the south and to the east, those are traditional R1 lots, 7,500 square foot or larger. This will be introducing a 3,000 square foot lot size in it. It's not compatible in terms of development form.
Yeah.
But the use is the same.
With green space, so that's the caveat.
Well,
I get it.
Yeah.
I'm asking.
I mean, just one thing I want to point out. Can you go back to the site plan, Mr. Schultz? The two site plans that we have. And I'm going to state the obvious because I know everybody knows this, but that's RN.
That's RN13.
That's RN13.
There's the 6.
It will go back to the RN13. It will be very obvious if somebody gets on Hamilton County GIS and clicks zoning that that's RN13. It will be very obvious if they then highlight where the property lines are when they're looking on Google Earth or in Hamilton County GIS, but it will not be obvious to anybody driving down Bonnie Oaks or Parkside Drive. The nuance that we're talking about, the difference between RN13 and RN16 is only visible today looking at that map. It is not even possible to tell the difference between those two zones when you're driving down Bonnie Oaks or up Parkway Drive. So while I understand that compatibility is an issue and we oftentimes talk about it, the reality is that I'm not sure one would ever be able to tell the difference between compatible and incompatible other than either A, they're driving on the new road, which they don't have to do if they don't want to, or B, they decide to get on some sort of computer and look at a map. Those are the two scenarios where it's obvious that there's a difference. I just want to point that out as we talk about compatibility and whether or not it's actually compatible. Did anybody else want to say anything? Mr. Maybe.
Thank you, Mr. Chairman. And I appreciate your comments there. And I do think you're correct in the sense of these two plans. I think, but when you look at the actual zone and what could be done without conditions, you could easily see that if you were driving by what could be done in one zone versus the other. So
yes.
I think there is a distinction to be made there. So that does make me concerned, or at least take into account the precedent that would set. Thank you, Mr. Chairman.
I don't disagree with that. And, you know, we heard Nathan.
I want to echo what you said as far as when you're driving down the street, you're not going to really see a difference between, well, I mean, you will see a difference to your point. I mean, if the RN16 plan is what is actually built, there will be a difference and
there will be
glaringly obvious, possibly.
Well, so we say things like possibly, and we have developers get up all the time, and this is directed to the neighborhood association. They get up all the time and they say, this is what I can do by right. And the neighborhood takes it as a threat. Well, that is not a threat. That is, you know, we have, as a developer, they're saying, we own this land and we are allowed to develop it by right according to RN16. We would rather not, because it's not as good. It's not as good for you. It's not as good for our future buyers. What oftentimes happens, and if you came to the 400 planning commission meetings I've been to, you would have seen it dozens of times where the neighborhood says, no, that's not what we want. And then the developer goes in and builds it anyways, because they can build RN16. And according to the two plans we're looking at, there is a difference from how it looks from Bonnie Oaks.
I guess a question for the applicant. Would you be open to going back to exploring the PUD for this site?
I mean, if that's the direction that I need to look at the PUD details more closely.
I can do that between now and city council, because I don't know. I have the old PUD memorized. I haven't looked at the new PUD in detail. It's something we're definitely worth exploring. Because I think we can still achieve the same results from a density perspective.
And I think
we can also achieve the same thing with conditions on R1.
Mr. Chairman, I don't think that the applicant can, as city council, just switch their PUD.
That's right.
It would have to
withdraw.
be resubmitted.
Yes.
You'd have to put a new site plan. There's a lot more detail that goes into a PUD.
Correct.
So it's more work on your part, certainly. I just want to say I'm generally supportive of the density of the RN13 zone. I think it's a good addition to the zoning code. I'm excited to see it used. And I think because this lot, to the chairman's point, is somewhat isolated, it is only on its own little cul-de-sac. You're not really going to notice it driving down Parkway Drive. You're just going to see the backyards of these homes. Same as if it were an RN16. So I'm generally supportive, but it sounds like the neighborhood really wants to see some protections. I have seen zoning cases, I can think of several, where a neighborhood has turned down what is a very good proposal that provides more protections than they have by right, and they've turned it down for whatever reason. I don't necessarily think this has to be one of those situations. I don't want it to be one of those situations. And so if the applicant is open to a PUD, I would like to see us move in that direction if that's a possibility. Obviously, I think at this point it would be more up to the applicant than anything.
Councilman Ledford.
Sorry, one more point. Sorry. There was a brief point about RN15 and using that as kind of the middle ground, and lot width was brought up, and the kind of step down from RN16 to RN15 to RN13 is pretty severe. And so I just want to highlight that going forward. This is one of those kinks that we're going to have to work out over the next, I don't know how long it's going to take, year, 2 years, 3 years, but it's something to track. How many times are people going to skip from RN16 to RN13 because the lot width of RN15 is not appropriately stepped? So I don't want to spend too much time on that. I just want to highlight it as something we need to be looking at as we move through this process.
Mr. Anderson.
Thank you, Mr. Chair. I agree with Nathan. I'd like to see this be a PUD also. Right now, we're starting to see really the first, this month is really the first big crop of new applications for the new zones that we've had. We've seen a lot of them. And while I was a big proponent of the RN13 zone being included in the new zoning code, it doesn't mean that it should be everywhere across the city. I think there are places where it makes sense in different parts of the city, not just the urban overlay. It makes sense in some of the outer parts too. But it doesn't necessarily make sense everywhere. And we see in the staff recommendations today an unusual amount of cases recommended for denial. And I think it comes from people like developers and applicants getting used to the new zones and trying to see, well, what can I get here? What can I not get? Everybody's trying to see how far they can push. I do understand the neighborhood not wanting it introduced into the area, because if we approve an RN13, somebody's going to be here in a few months wanting to take the 7,500 square foot zones that exist and turn them into 2 each on existing streets. And that's a real issue that's a part of this. So we have to think about it in that context too. So thank you.
So thank you. I think what I've been trying to say has been heard relatively clear in the RM13, and you're right, Mr. Anderson. We talked about this before about how we would see these, and we're going to see a couple more as we move on through today. So my question, though, and thank you, Commissioner Berg, you're on track. I would love to see this go through as PUD. But the cleanest way to do that is for the applicant to request a withdrawal and then move forward. Because if you compare the maps, just compare the two maps, I will pick that RN13 map any day of the week, hands down, because it, like you said, Chairman, you will not tell the difference driving down Bonnie Oaks, but you will tell the difference if that corner is preserved and it is locked down into a legal document that preserves it and keeps the character of the neighborhood and protects it as much as possible by allowing also property rights. So the question for the applicant is, given what you've heard today, And I apologize to everyone. This has been quite lengthy, but you're probably going to hear this a little bit more as we introduce the new zone. Is that an option that would be acceptable to you? If so, then the right thing to do would be to, at this time, would be to ask for a withdrawal and reset, so to speak.
Unfortunately, I can't make that decision right now.
Understood.
I do represent the developer who owns the property. I will take it to him, and because this is the recommending body to city council. This is not an ending decision. But between now and city council, I will give it to the developer and see if he wants to proceed with another 3 to 4 or 5 month process to go through a PUD, because that's what it's going to take, or just continue on with R16.
So a motion to deny today would kick this back for reapplication. 12 months, 9 months to plan.
No, it's at city council level. If it's denied at city council, it is 12 months.
9 months.
12 months. That's
12
changed.
months, 12 months.
But that's
So-
at city council level, not from today.
Right. So if we, and this is a process that we need to understand clearly here, so I'll ask this question to staff. If this were to move into a deny or approve, do we have the option to obviously stop this at city council, withdraw it before, obviously, correct? We still have that option and start over. If it's denied, staff, this is a question for you. If it's denied, will it come through? It cannot be withdrawn from city council if it's denied. Is that correct?
If it's denied, action has been taken.
Yes.
Therefore, the council rules does allow people to bring it back up for vote. I'm just not sure how that works, but yes, if it was denied, never brought back up, he can develop the property as zoned, which is already in 1-6. Now, if you want to come in for a PUD, you have to wait a year.
Okay. Now, obviously, the other option is we have an option to defer for 30 days, which moves us into the next conversations.
Right. So let me get clarity on what
I'll leave it up to you.
Well, let me get clarity on what your statement was.
Sure.
So if planning commission denies, we can still withdraw before city council and still reapply in December under a PUD request.
Correct.
I believe that to be true.
Okay.
Yes.
Okay. So, I mean, I don't want to diminish what this body does, but an approval or denial, we can still withdraw by the end of the week from a city council perspective and pursue the PUD. Is that what I'm
Under a
understanding?
new application.
For a new application, correct.
Yes.
And start the cycle.
I believe
over.
that to be true from my experience.
Okay. Does that sound correct from a staff perspective?
Yeah, as long as no action has been taken at city council. Now, once it gets advertised, RPA doesn't have any control it actually coming off city council agenda.
I can make it. The developer can make a decision by the end of the week. I just, yeah.
All right. Then I'm going to move to make a motion to deny.
Second. I do have a question before we vote on this. Just so you've not talked to the person who owns it, all right? You obviously
not as
since you've been here. I mean,
correct.
in the last 30 minutes.
Right.
If we vote to deny, whoever this person is could say, the heck with it. I'm developing it like it is right now and just pull it and go develop what he wants to develop like he wants to develop. And he doesn't have to go to city council. He don't have to do anything, correct?
That's his choice.
That is correct.
Okay.
We have a motion to deny and it has been properly seconded. Go ahead. Any
So-
discussion?
Yeah, I did. So I do think the neighborhood spoke very, very eloquently about this, and they're represented very well. And she's standing to comment. Now, if the chair would allow.
That'd be fine. We do have a motion on the floor that has been seconded, so keep your comments brief.
Oh, that'd be brief. Thank you for taking so much time to discuss it because it's really important to us. I think that there was a lot of focus on the green space, but there are things like the entrance, the main entrance. One of the main concerns for the community is a whole new subdivision using the main entrance. And I just don't want that to get lost because that was a huge part of the conversations, was an option to come off of Bonnie Oaks into the subdivision as opposed to coming through Battery Heights because it's a historic neighborhood. Those pillars are like part and it's a subdivision. I would be a poor representative of my community if I didn't make sure that that was also a consideration if there is an intent to come forth with another plan. Because right now, the zoning that we're like supposed to have, the R6, like I just think that we could keep green space and have R6. So I just want to say that because I know it's really important to my community. that their proposal, if there's an alternative proposal, we did ask for this, would be come off Bonnie Oaks instead of using the historic Battery Heights entrance.
Councilman Ledford.
Sheena, that's a good question. And by resetting, I'm going to use that word, resetting to a PUD process will actually give you that ability to have more conversation, and whatever is decided upon will then could be locked down to a site plan. As it sits now, we do not have that capability. So the PUD process is actually designed to protect and to enhance amenities for the community, and that's why I felt so strongly about the use of a PUD in this particular situation, and going forward, so that we don't abandon that creative tool.
Yeah, thank you. This is an education. It's been a lot of research. I didn't know most of this vocabulary when this whole thing started. So every little bit helps.
Welcome to the club.
Yeah, I'm exhausted. Thank you.
We have a motion and a second on the floor. Any further discussion?
Yes, sir, Mr. Chair.
Mr. Lyle.
Thank you, Mr. Chairman. I agree with a lot that has been said. I guess to Commissioner Payne's point, I feel like I'm in a really tough spot with the denial motion on the floor. Is because if Mr. Jones's conversation doesn't yield that the process would be desired to move towards a PUD, and the denial carries forward, then the better of the two options no longer sits on the table. And I agree with the precedent being set as the bad thing. But I guess my question would be then, if Planning Commission recommends denial and the property owner doesn't want to move forward with the PUD, does the council have the ability to not follow our recommendation and move forward with the RN13 to achieve the more desired option?
Yes.
Apologies for being slow.
No, that's quite all right. Any further discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries.
Hey, somebody else. You're getting paid.
I get paid a little more.
You get paid too. You get paid
Oh.
city council. Not for this. It's not extra. It's not. The chair and vice chair does, but not the planning and zoning chair. So technically, no.
All right, next case on the agenda, and the first item under new business is case 2024-0172, and this is located at 805 Warlick Way, and it's a planned unit development abandonment, and staff is recommended to deny the applicant's request. Is there any opposition present? All right, and is the applicant present? Mr. Price, thank you. Mr. Schultz.
Yeah, Mr. Chairman, we did receive some emails in opposition to. You should have those in front of you. This is a abandonment of a PUD. This property was rezoned to RTZ back in 1996, I believe, with no conditions. This was approved for a PUD in 2018. It's roughly 18 acres in size. On the approved PUD plan, it was approved for, let's see, I have it in my notes, 23 single-family lots. They're wanting to now go to 31 lots. That's a density of 1.68. So it's not a rezoning, it's abandonment of the PUD. There's no zoning history on this site except from 1996 when it was originally rezoned from R1 to RTZ. There is no conditions. In the staff report, we originally noted the equivalency zoning would be RN2, but after further discussions from other projects, later on after the staff report came out. Our new equivalency zoning would be TRN3 with 2 conditions, which would be only residential allowable uses are single unit and townhouse, or a maximum density of 8 units per acre. That would be the new equivalent zoning on this property. But the applicant's requesting to abandon the PUD. It's single unit detached to the north, single unit detached to the south and east, and vacant land to the west of the site. Here's a view of the site. North of the site, which is single unit. East of the site, single unit detached. This is west of the site. This property is in the East Brainerd Plan, which is adopted in 2022, and it recommends suburban residential with a partial overlay of natural resources due to the floodplain that crosses this property to the rear. And one of the primary goals of the East Brainerd Plan was the protection of floodplain. Here's a closer view of that site in the red dot. You can see it's suburban residential with a natural resources overlay. This was the approved PUD plan from 2018. It was all single family detached with 23 single family dwellings with a density of 1.25. Here's a screenshot of the proposed site plan with the abandonment of the PUD. Again, it was approved for 23 lots, density of 1.25. If this PUD is abandoned, the developer said to do 31 lots with density of 1.9. That's on the site plan. Nothing holds the developer to that. There is no conditions on this if if the PUD is abandoned. So staff recommended to deny the PUD abandonment, and because you could potentially, if it was zoned RN2, again, this is based on RN2, these numbers are a little wrong now. If the PUD was abandoned, you could, in theory, get 125 single family dwellings on this property or 580 townhouse units based on the overall 18 acres and the lot size requirements in RN2. Staff recommends to keep the existing PUD in place. That way it controls the number of units on that site at 23. So staff recommends to deny the PUD, leave the existing PUD in place to control density on this site.
Councilman Lidford. Okay, so Brian, help me out here because I've run a lot of math on this. You're now saying the equivalency map is not an RN2, but it's going to go to TRN3.
Yes, as of Friday, Karen and I,
Friday, right.
we've been going through this back and forth on what we should do with some of these zones. And my understanding, the RTZ with no conditions based on our equivalency mapping, we go to TRN3.
Okay.
Based on a 3,000 lot size in the TRN, you can get 213 single family lots. However, one of the conditions will limit this to 8. You can still get a lot of units on that at 8.
So run that math for me because my math is now out the window with everything that I've been working on.
18.3.
Well, it changed Friday, folks. I mean, I've had all these numbers ready to go.
That's roughly 144.
Okay.
So the request, if the PUD's abandoned, goes to TRN3 based on the equivalency of zoning, you get 144 single unit detached. The PUD controls that at 23 currently.
And the request is to go to 31 over 23.
Well, that's what the PUD, that's what the site plan shows. You can't put conditions on abandonment of the PUD plan because it's not a rezoning.
Plan, though, that supports that.
Correct.
Mr. Price.
Mr. Byrd. So to clarify 3 things here, this is a request to abandon, but we don't see any replacement because I know that sometimes happens where we abandon one PUD and replace it with another. That's
Right. This is not that. Because
pure replacement.
Yes, because you look at it really this way, it could have been a PUD abandonment to add more lots. It's a major change. But since that PUD tool didn't go away, we changed the PUD tool in this new zoning code. So they want to get more lots in this development from what was approved at 23. The site plan submitted shows 31, but once that PUD's abandoned, there's no guarantee that it would not be more.
Right. So 2 more questions. I may have missed this in the initial review. When was this property rezoned to RTZ?
1996.
And when was this PUD adopted?
2018.
Okay, thank you.
Mr. Price.
Thank you, Mike Price, MAP Engineers. So let me first put everyone at ease, so to speak, that the intent here is not to develop 580 townhomes or 125 single family homes. Matter of fact, if someone at the RPA can draw that on this property, I'm hiring them because I don't know how you do it. So the request is simply to abandon the PUD and put 31 single-family homes on the exact same property, the exact same road layout, leaving the community area exactly the same. Now, our preference as planners for this property, as an engineer, would have been simply to amend the PUD, come back in and said, give us 31 lots, please, 50-foot wide minimum lots. We won't do accessory dwelling units. We'll make it all single family that matches with everything else in Heritage Green. That would have been our preference. But that's not a tool that we're being told to utilize anymore. So we took what staff told us based upon the new ordinance, and that's what we moved forward with. That has now created, I think, a little bit of angst based upon what I'm even hearing from the last discussion on the last case. So I don't know if there's an ability to simply amend the PUD and go to 31. That would be my preference. But again, we're not looking at taking out community space. It's wetlands. It's deed restricted, truthfully. It will remain that way. So there's going to be over 11 acres that will remain in community space. If you want to make that a condition under the current request, I'm good with that. But again, we're not doing anything that is really outside of the box of what's already in Heritage Green. It's just going to 50-foot wide lots, period, single family. The exact same road layout that was shown in 2018. That's it. It's an increase of 8. Nothing more, nothing less. Happy to answer any questions from there.
Right. We could always deny a preliminary plat because the applicant lied to us when they got the rezoning. So I'm just saying that clearly we can deny a preliminary plat. We could, while in some cases we can't hold a developer's feet to the fire, we can deny a preliminary plat if the preliminary plat were to come back and be 245 lots. We would say, you lied to us. Right?
You could deny the plat, but it's had to be based on some public health and safety.
Not a commitment from the developer?
I'm not a lawyer. I'll defer.
Because I guess what I'm saying is this PUD being lifted does not grant permission to build these roads. It still requires a preliminary plat.
That's correct.
Which we don't have to approve if the applicant were to come back with 40 or 50 homes on this piece of property.
Yes, the planning commission can approve or deny anything that's related to public health and safety.
Could we deny a preliminary plat if it came back with 35 lots on it?
I'd probably argue what's the public health and safety reason for the denial of the plat.
We couldn't deny it simply based on the fact that it didn't meet the number. Okay.
Yeah, I defer to Dan. I don't know. I don't think you could. But.
Mr. Byrd, I've got two questions for staff. First, can we get the city attorney, somebody from their office, to start sitting in on these meetings? Because this has happened multiple times where we've had a question where everybody raises their hand and says,
I would say the questions aren't that hard from a legal standpoint. They seem hard to y'all sometimes, but I mean, I think some of these are not that difficult.
I believe you. I'll say I believe you on that, but it would give a lot of people in this room a lot more confidence.
I understand. But I mean, there is kind of it's kind of a thing that we do in the development community of trying to, come in here with a lot of good arguments. This is a legal hearing in a sense. So, I mean, I'm just saying city attorney can be requested to be here absolutely by the planning commission anytime.
I would like to go on record requesting that then. I mean, I sit on the historic zoning commission. We always have the city attorney there. It's very helpful. Not every meeting, but it comes in handy. It really does.
If we go back to the screen I had on earlier on the subregs, really the denial is based on some type of, not in the best interest of the city or a public health and safety benefit. If you feel that 40-something lots in here is a nuisance or an impact on the public health and safety, yes, you can deny it.
And second question, when y'all were researching this area for the equivalency mapping, did y'all just take into account the underlying zone, or did you take into account that there was already PUD in place? How?
It's underlying zone. I mean, we're doing equivalency zoning.
From the underlying zone, You didn't take the PUD into account. You just said, here's the zone
Yeah,
now.
we're looking at something that's equivalent. And
And
that's what
here's the zone that
we
it
realized
should
that
be in
as
the
of Thursday
Okay.
or Friday, the TRN3 zone is the more appropriate zone that should be on this property.
Okay.
It comes with two conditions, single unit and townhome, and 8 units max.
Got it. Thank you.
So if that PUD's lifted, it goes to TRN3. It's going to TR3 regardless.
Mr. Maybe.
Yeah, thank you, Mr. Chairman. This probably best for Steph. Mr. Schultz, so would it have been possible to just amend the current PUD to this?
You could amend the PUD. It's a little gray because we've got going through right now a new zoning code, new PUDs. But I think you can just amend the PUD.
Okay.
It does. The PUD currently, it's just like the old PUD in terms of major, minor modifications. This would fall under that major modification as the density is going from 23 to 31. So in theory, it would be just a PUD amendment.
Okay.
If that's something y'all want to act on, I think that's possible.
I guess I'll carry that on to the applicant then. Is that something, Mr. Price, is that something you consider?
We would certainly do that. I mean, again, even going to 31 lots, the density would be 1.69 units per acre. So it's pretty benign in terms of what we're requesting. And we're fine going that particular route if that's the direction. I think we certainly need to hear from the neighbors, but yes, that would be something we would consider.
Mr. Price, would you also include those conditions?
Oh, absolutely. Yeah, we would work with yourself and also the neighbors and figure out, what conditions we could put on there that would give them the comfort level and also staff in terms of how to move forward if we can go in that direction. Yes,
Sure. And I also want to hear from my neighbors, but Brian, let me ask you this real quick. So if we made a motion, Mr. Maybe brought this up, if we made a motion to amend the PUD to allow 31 from 23, which is, I like the 8 versus 144 all day long, considering what we had worked on in the past, that would have to accompany a new site plan. Can that site plan be submitted before it is heard in planning and zoning at council?
I believe this is the site plan he wants to use here. This is PUD plan.
This is the site plan to replace?
Yes.
So we have the site plan, we have the request, we have the conditions.
There are currently, excuse me, I don't think there's any conditions that I remember that were on the current PUD, but we could certainly add whatever conditions that would be appropriate.
I don't know about the PUD. I know there was no conditions on the zoning. And the weird thing for us is the way the PUD's written today, the way it's written today, of course, it doesn't take effect until December. You have to have an approved PUD plan approved by the council. Then you're coming back in amending that. This was done, but it's back in 2018.
I remember. I hope.
Yeah. So I think it's to make,
And we
staff
faced
correct me
the
if I'm
same-
wrong.
We faced the same thing then, which was hundreds versus
Yeah.
a group.
With a PUD plan, as shown here in 2018 of 23 single family, that was the density. You can only do 23. Even if it came in at 24, it'd have to be a major PUD. It's not the density per acre, it's the number of units.
I think that would be our preference too, though. I mean, to amend the PUD if that's an alternative.
I think so. Since we're in this transition, going from the old zone to the new
It
zone.
makes sense. It makes sense, but I do want to hear from our neighbors. If I may.
If you're here and you're in opposition and you wish to speak, please come up to the podium. State your
James
name and
Wells.
address for the record.
I live at 775 Warlick Way. So currently, the land that they're asking to develop on is floodplain. It is below floodplain. So if you build there, you got to bring a ton of dirt in. So which floods us. So if you look currently at Davison Road, there is a development going in place on Davison Road right now. They have brought dirt in that. So the whole time I've lived there, 12 years, they've been bringing dirt. So they have destroyed the roads from the dump trucks, and now they are flooding the backside of Audubon Acres, which that land borders Audubon Acres. So all of that water, if you build this up, it's going to flood us. So there's no plans on developing the land. The current access is between two houses, which isn't wide enough to get trucks in. There's that lot there is not wide enough to bring in equipment. So both of those neighbors are going to have to give up some of their land, or they're going to have to fight it out, or however that works. But that lot is not currently big enough to bring in heavy equipment. They, about 3 years ago, they clear cut this land and they went in, they ran perk tests. Every hole they dug filled up with water in just a few minutes. It was definitely failed perk. So to now, and those are bigger lots. So now you're going to make the lot smaller. There's no way that land will, I mean, it's a sponge now. So every time it rains, there is a, just on the other side of the lot you're looking at, there's a city drain. Then the house that's on the left side of it, the next house is mine. The next house, there's another city drain, which drains behind my house to a French drain going into a retaining pond. So when they cleared it the last time, they left a large amount of debris back there. Never burn it, just a huge debris that changed the water flow. Where the city flow comes out, that French drain now is almost stopped up because of debris from the last clear cut that was never cleaned up. And both of everybody on Warlick, when it rains, we get water right to the fence line. So that's my concern, is the flooding. And if you look at, like I said, look at Davidson Road, huge amounts of flooding.
Hi, I'm Julia Henry. I live at 793 Warlick Way, so I'm adjacent to 805. I am really concerned that would be the only entrance and exit to the development, and it is very small. We were actually approached several years ago by the developer asking us to sell 10 feet of our property so that they would have sufficient ingress and egress, which we did not want to do. So I'm unsure how that changed, and now it's doable. Also, our neighbors were not notified. I called a month ago to ask when we would get letters of notification, and the Regional Planning Commission told me we would get letters within the next 2 weeks. Well, we never got letters. So I called last week, and all of the letters were mailed out to residents on Callaway Court. So none of my name, I have the letter, I have the list of the contact in my purse if you need to see it, but no one that was affected by it was actually notified. So even if we could have consideration for a postponement so our neighborhood could get together and be more prepared, but no one that was notified on the council's list had anything to do with it. I'm definitely affected. It's in my backyard and I didn't get a letter. I had to call and ask for my own copy, and someone was kind enough to send it to me for me to hand out to my letter to my neighbors. But no one on Warlick Way or Norfolk Green was ever notified officially. If you'd like to see your census, your letter, but it was all Callaway Court, which will be affected on the backside, but they're going to have the nicer end with the wetland, the preserved wetland. All of us on Warlick Way, we also have sump pumps because we all flood. And I'm really worried about that property being built up because we all flood in a heavy rain. We all have to have sump pumps to remove the water from our houses. But proper notification, I think, would be the first step before it's readdressed. So it could be readdressed.
Thank you, ma'am.
Thank you.
Simpson, 813 Warlick Way. I'm the neighbor right beside them, and we're worried about being affected by the runoff and the lot sizes. 50 feet wide is not in keeping with the rest of the neighborhood, and all the roads around the neighborhood are being greatly affected by the development on Davidson, like our other neighbor had said, and there's several roads right around our neighborhood already destroyed. There's big giant potholes. I drive a pickup truck, and my pickup truck scrapes on the damage that's been done by the trucks that run to the development on Davidson. And mine is the, if you could go back to the one where it shows the entrance, my house is the one on the right. And the ditch for stormwater runoff is just like he said, it comes up to our fences already. And if they have to add dirt to develop that more, it'll be in my backyard because that drain already does not work well. Thank you.
Does anybody else wish to speak in opposition? Mr. Price.
So there is sufficient room between the two homes as it relates to constructing a road and sidewalks coming into the development through there. We do show on the site plan that we attached, there is a dashed line that runs through there. That is where the current 100-year floodplain is as mapped by FEMA currently. Obviously, the topo will give us a little bit more information. We did not do the engineering on the front portion there that connects to this, but with the engineering that we would do, we would not be flooding the neighbors. We would be conveying the stormwater into the floodplain, putting it into a retention facility and discharging it from there. I would point out as it relates to how these homes are located, none of these homes would be facing any other resident within the development. These would all be facing themselves or backing up to residents. So 50-foot wide lots, which is sort of your new standard, is not diametrically opposed or different than what they're seeing, because they'll see what they currently see, which is their neighbors across the street. We back up to them. So that's a totally different scenario. And 50-foot versus 60-foot on the lot widths is hardly much of a change as it relates to the widths. So happy to meet with the neighbors. So I think the PUD is the direct and best way to go. I would like to see if that is an option, and if so, then we can meet with the neighborhood between now and prior to going to city council and discuss any other concerns. We could arrange neighborhood meetings certainly in that time. Any questions? Happy to answer those.
Mr. Anderson.
Thank you, Mr. Chairman. Mr. Price, I heard a lot about stormwater and acknowledging that stormwater is not within the purview of this body. I want to say that to get it out of the way. What do you plan to do with stormwater?
So we have proposed as part of our development to provide stormwater detention facility, which is located towards the end of the cul-de-sac. There are 2 ponds that we have located there. There's also a large drainage channel that comes out of Heritage Green. My guess is it's probably overgrown, probably could be a result certainly of that clearing that might have taken place years ago. Don't know, but we would certainly look at that and then channeling that into the current waters of the state that are located on the plan that we show. I would point out that this area does not drain well. I lived in the subdivision for 15 years directly across the street, so I'm familiar with the area. I get it. That area in through there has got a lot of wetlands. It's got a lot of slow areas in terms of the ability of water to drain off, but with what we would do in through here would have no impacts with regards to flooding their residents.
Any other questions for Mr. Price? Mr. Ledford.
So Mike, talk to us about how TDEC plays a role in our stormwater management, because number one. Number two, familiar with Davidson Road, obviously, the number of trucks, the infill. Are we expecting that much infill as we saw on Davidson? Because quite frankly, I don't think people can handle it.
Yeah, no, Davidson was unique in terms of the amount of dirt that was brought in. We are not contemplating anywhere close to that. There will be some dirt that will need to be brought in as a result, but not in the quantities of anything close to what that was. We're much smaller, for one. Number two, our topography is such that we don't really need to raise it more than a few feet in most areas on the site. We'll also be undercutting as it relates to in those ponds, so we'll be able to utilize some of that material as well. So very little as it relates to TDEC. TDEC typically is looking at erosion control measures and the protection of streams and wetlands. The city of Chattanooga is the one who will look at the work that is being proposed and ensuring that it complies with city standards for water quality, but also will not impact as it relates to the other residents that we would back up to. So I think given those checks and balances, and again, we'll have discussions with the residents and we can talk further as it relates to some of the specifics, but we certainly pay attention to stormwater. That's one of the things that we pride ourselves in terms of being able to manage, and we would do the same thing here.
Well, doesn't the law prohibit you from impacting your neighbors?
You cannot add water nor really take away as it relates to the runoff that goes onto other people's property. What I would say is that I would envision some sort of drainage system that would back up to the residents that we would adjoin, and we would be picking that water up and conveying it out. So in truth, what they should see is actually an improvement, I believe. But until we get into the full engineering design, that's my belief, but I don't know for sure until we actually do the design.
So in the past cases, I have asked engineering, well, I've asked the engineer on the project to over-engineer stormwater retention and stormwater management. I'm going to ask you to over-engineer it above what the city requires. Now, I know that legally we cannot hold you to it. I've done this long enough to know that. But I do know that if it is written, if it's mentioned, if it's put into a PUD, some sort of document, even if it's an appendix or addendum, that it does have some good faith to it. And I think that not only does it warrant it, knowing what I know about that area, I think that would be a good faith movement. So let me put a pin in it right there and go back to staff. Abandoning this PUD scares me tremendously going to TRN3. Really scared me going to RN2. So much I lost sleep over it. I do not want to see the PUD abandoned to go to TRN3. Then we are in serious trouble out there. I do think amending this PUD, working with the neighbors, creating assurances in stormwater. Again, not this body's purview, thanks for pointing that out. But, you know, people come down here to hear us hammer these things out, so to speak, and make sure that we're working on behalf of their best interests as well. Because right now we have 23 to 31. 8 doesn't seem like a monumental increase due to what it could be to 113 probably. So that is definitely something I don't think anybody here would want to see out there. And then you've offered some additional conditions that we could place into at the council level meeting next month. So can I make a motion to amend the PUD to 31, accept the site plan with the conditions that have been proposed by Mr. Price? And obviously we have time before it comes to council to have further conversation and time to meet with everyone that's here.
Yes, I think you could recommend to deny the applicant's request to abandon, but approve a modification or amendment to the PUD to go from 23 to 31 lots.
Right now, I feel like that is the safest thing to do. So that is my motion.
Second. We have a motion and it was seconded. And then you had mentioned some conditions proposed by the applicant, but
yeah.
I didn't catch those.
Mike,
single family only, no ADUs, and minimum of 11 acres to be community lot, and minimum lot width of 50 feet.
So we have a motion. It has been seconded with conditions. And has staff got those conditions?
Yeah, we'll get them.
Okay, thank you. Any discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries.
Thank you.
Everybody huddle up back there.
We're going to take a 15-minute recess. We'll start back at 3:20.
Thank you, sir. Yes, good to meet you. Yes. So did your buddy retire?
Go ahead and jump back in. Thank you all. Next meeting on our agenda is item 2 under new business, and it's case 2024-0180, and it's at an unaddressed property in the 8700 block of East Brainerd Road. It's an application to rezone from A1 to R2A, rural residential district, and C2 local business, commercial district to R3 multifamily. Residential district, and staff is recommended to approve. Is there any opposition present? Is the applicant present? Thank you. I entertain a motion to approve. You want to hear about it as a motion to approve? Okay. I need a motion. Okay, I have a motion and a second. Any discussion? All in favor, say aye. Any opposed? Motion carries. Next case on the agenda, item 3, is case 2024-0181. And it's located at 803 Dodds Avenue. And it's an application to rezone from C2 and R2 to CMU-1. And staff is recommended denying the C-MU1 commercial mixed use zone and approve a CTMU transitional mixed use commercial zone. Is there any opposition present? Is the applicant present? We have a motion to approve with the staff recommendation. Is there any discussion? All in favor, say aye. Any opposed? Motion carries. Next case is item 4 on our agenda. It's case 2024-0182, and this is located at 109 Guild Street. And it's an application to lift conditions from ordinance number 13337. And staff is recommended to deny the applicant's request and approve other. Is there any opposition present? Is the applicant present? And are you familiar with the staff's recommendation on this? And you're fine with it? We have a motion to approve the staff's recommendation that has been properly seconded. Any discussion? Hearing none, all in favor say aye. Any opposed? Motion carries. Next case on the agenda, which is item 5, case 2024-0183. This is located at 1733 Mitchell Avenue. It's an application to rezone from URD2 to URA3. Staff is recommended to deny the applicant's request. Is there any opposition present? Is the applicant present? Mr. Schultz.
Yeah, this is a request to rezone from URD2 to URA3. This is the form-based codes. The developer wants to take a single-family detached dwelling on this one lot and convert that into attached units. It's roughly 0.13 acres in size. It's 3 units. It's a density of 25 dwelling units per acre. If you look at the zoning map, there is no URA3 nearby except 2 parcels or 3 parcels to the east of this side or the right of the screen. Again, there's no zoning history on this side except form-based code when it was adopted in 2016. 1733 Reed Avenue was rezoned from URD2 to URA3. Again, 1 block over. Single unit to the north, single unit to the east, commercial to the west along Market Street, and to the south is utility and convenience store and some new apartments. Here's a view of the site. You can see it's single family to the north. Again, this is north of the site, a single family detached dwelling. This is south of the site, east of the site. This is west of the site, Market Street. This is in the downtown south side plan. It doesn't really give guidance on land use plan recommendations, but it says construct a range of new housing around Jefferson Heights Park. This mix should include single family housing, duplexes, and apartment units. Here's a view of the site plan showing 3 attached units on this parcel. This request would not be compatible with adjacent land uses in development form, as adjacent uses to the north are single unit detached. Again, you have commercial to the west and you have single family to the east. UR3 is not a zone or building height consistent with the zoning of this block. Again, most of that's URD2, which is single unit, 2 stories. This is a very small lot, which will make it difficult to develop due to the protected zone requirements in form-based code. Staff also has concerns about curb cuts that would be introduced in this block because the site does not have any alley access. The property was rezoned 1 block over, which is on Reed Avenue, was rezoned to URA3 in 2022. It was more appropriate at that location for attached housing because that lot was larger in size, located near an industrial plant and multifamily residential. And that lot had alley access, so it was more appropriate at that location than this site. Again, this proposed site is smaller in size and adjacent to single unit detached residential with ADUs. Staff recommends to deny. The most appropriate use of this location would be a single unit detached dwelling with an ADU.
Thank you, Mr. Schultz. Any questions for staff? Mr. Chambers. Can you turn that mic on? Or there you go.
Oh, there we go. Rocky Chambers, 400 East Main Street's our office. Brian, can I get you to go back to the overall zoning plan? That wouldn't work. Yeah, we looked at it and looked at the surrounding uses before we said, hey, you know, let's try and fit some townhouses on the property. As Brian mentioned, you know, just to the west of us, we've got Market Street and some commercial or previously used commercial properties right along Market Street that we back up to. Across the street, vacant lot, and then some more commercial over there. Diagonally across the street, there's about 100 townhouses on that piece of property, and then 2 properties over. There's more townhouses, almost exactly the same as what we're trying to do here. So, you know, looking at the surrounding areas, looking at the surrounding uses, this looked very similar to what's being used around us. We do recognize that there is other single-family detached directly adjacent to this property, but there's a whole lot of townhouses near us. And then, like I say, the townhouses 2 properties over, very similar to what we're doing. Our density is a little bit lower than theirs. They do have alley access for all theirs. We have alley access for one of them, so there are some differences there. Their lot width is a little bit wider, but very similar, very, very characteristic of that property. So we looked at it. We said, hey, this would look really well there. I don't know that half a block off Market Street we could actually sell a single-family detached unit there. So yeah, so that's why we're here today, is to explore the idea of doing townhouses.
Any questions for the applicant? And are you here in opposition? Okay, we'd love to hear from you. Is there anybody else that's here in opposition? Okay, thank you. Come on up.
I didn't intend to speak, but after 2 hours, I thought of quite a few things to say. But,
sure.
Yeah, I've never been to one of these meetings before, so.
Well, you've got 9 minutes, but you got to state your name and address for the record.
Brett Weaver. I live at 1731 Mitchell Avenue, right next door to the development. And just to give a little history of the old house that was there was torn down about, I guess it was almost 2 years ago, January 2023. And the guy that I was under the impression that, you know, you can see my house right there. And you can see the one board on the fence that got hit by when they tore down the old property. But that's been torn down since 2023. And I was under the impression that the owner was going to build his own personal residence. And so I met him, and I was, you know, trying to be neighborly. And I believe in, you know, treating your neighbors well and being neighborly. But I'm a little concerned just with the other properties he's got. There's several of the properties have used car lots around. If you've noticed a lot of the images, there's just older cars. Some have been parked on the sidewalk, and the lot it's been not always well maintained. I'm a little, well, first I'm concerned is he going to sell these units or rent the units? are the units for sale or for rent? Do we know that?
No, we may not know, but you're welcome to ask us whatever questions you want.
Okay. Well, as far as the neighbors there before were really nice folks, but I didn't always see the property being well maintained, and so that's a little bit of my concern. It was an older house, and their power was always it was always out. Or I remember their church had to come help them paint the house, and on one occasion I let them run a power cord to my porch so they could have power to cook their Thanksgiving dinner. So I just want a little transparency on what's being built next to my property and how it's going to be maintained. And without saying too much more, I don't want to throw anybody under the bus or talk. I mean, it's good neighbors, and I want to be a neighborly person in my neighborhood, but I'm against the rezoning of multiple family. I would rather see it be, like you say, a single family unit. And those are just, I mean, in a nutshell, those are my concerns. And there's also been a flooding issue too. At one point, this property was the lowest point, and now it's already been built up in the process, and a lot of dirt's been moved in. And so my property becomes the lowest point at this point if more stormwater is diverted, to my backyard. It almost flooded. I think it was a couple years ago when we had that major flood, and I think it was April, but it came all the way up to our basement. So I have concerns that development is going to change the flooding patterns too. But, those are my concerns.
Thank you. Did you want to say anything?
My name's Tom Hagan. I'm at 1723 Mitchell Avenue, 3 houses up the street. My concern is, he said one of the units would have access to the alley. I think there's a huge drainage pipe there, and I don't think there would be access. If there was access, it would affect that drainage. I'm also interested in parking for 3 units. We are in the Fort Nagley parking district on Mitchell. We have to buy passes to be able to park. It's getting crowded. So I always thought there would be a single family house on that corner. Thank you.
Thank you. Mr. Chambers.
Thank you. I'd first like to say I really wish I have neighbors like these. To let someone have power to have Thanksgiving dinner, especially this time of year, sort of resonates. So certainly commend you for that, and then spending a couple hours with us today as well. Heard a few things, so let me just kind of tackle some of those. Question about stormwater. The city of Chattanooga has a really robust stormwater ordinance. It's about 700 pages long, and we need to make sure that we are neighborly as well. We don't, flood our neighbors or cause adverse effects downstream. I'm not sure what was done previously. I wasn't involved at that time, but anything that we did moving forward, I would have to be involved with and make sure that stormwater concerns are addressed. Also, a question about parking. City of Chattanooga also has parking requirements to make sure that we have adequate off-street parking for each of these houses as well, so they won't be clogging up the on-street parking as well. And then just general comments about, hey, let's whatever's done there, let's make sure that it's an asset to the community. And I think by and large, most new developments are an asset to most neighborhoods. You'll see property values around you go up as more investments put into the neighborhood. You'll see, people who are moving into these newer homes. Obviously, they're spending quite a lot of money on their homes, and they're having to meet certain bank requirements as well. There's a question brought up about owner occupants or rentals. I'll say that the intent of this is to build it to be able to be sold fee simple. So townhouses that can be sold fee simple, just like the 100 or so that was built across the street. So that's certainly the case. Whether or not an owner puts a tenant in there or not, I can't answer that. We won't always own that. Any other questions?
I do have one. One of the other issues that was brought up was parking. So what are the parking requirements in the zone that you're requesting, and what would you have to do?
Ryan, I might have to ask for some help here. Last I knew, if we're doing 2 bedrooms or more, even in this district, we still need a couple of parking spaces. Is that correct? Yeah.
Any other questions for the applicant?
For the zone itself, yes. I'd have to look up the setbacks from dissimilar zones, but front yard, we have 10 foot and rear yards, we have 5 feet.
And that's the minimum setback?
In the zone, yes.
Well, this since it abuts RD2, that's a protected zone. They go to 15 for the side and rear.
Yeah.
So I think form-based code planner looked at that and said there may be issues with meeting that setback. May need some modifications.
Mr. Anderson.
Brian, on this property, what's the side and what's the rear? I understand how the lots of it was originally platted, but I see 3 driveways coming off of what we would maybe call a side.
Well, side, I guess.
How would that be interpreted, side or rear? What's the front really is the right question.
Was that street?
That's 19th.
19th, I guess it'd be 19th, be the front, and the rear be the ones in front of the URD2 zone.
So
This being a corner lot, you'd have front setback on both sides of it being a corner lot.
So you'd have 15 in the front, 15 in the back. Is that right?
Yes, 15
5,
regardless.
And then 5 on these sides, which would include a side of Mitchell Avenue and a side of the alley.
Mitchell's going to have a front setback of 15 because that's a corner lot.
Okay, 15, 15, 15,
And 5.
Got it. Thank you.
And we're still looking on the parking standards.
Brian, can I
Yeah.
I hate to interrupt you. I don't know if somebody else is looking. So relative to the staff recommendation, is that because there's no adjacent property zone? Because you typically think about maybe a transitional zone for maybe the commercial on the 19th Street as it steps back. I'm just curious. Was it because there was no other RA3 adjacent?
That partially, and then the other URA3, like I said, to the blown block to the right was a bigger lot. This is a small lot, and then you're budding primarily a single family dwelling. I mean, subdivision north of this side. That's primarily the reason behind it.
Okay.
I believe it's 1 space per unit.
Okay.
On parking.
All right. Well, as a reminder, we're not approving the site plan, just the zone. And what's the will of the commission?
Move to approve.
Second. We have a motion to approve, and it has been properly seconded. Any discussion?
Okay.
All in favor, say aye.
Aye.
Any opposed? Motion carries. Thank you, Mr. Sanders.
I can get my computer.
Next case on the agenda is item 6, case 2024-0184. And this is located at 8113 Graham Road. And it's an application to rezone from R1 to RN2 residential neighborhood zone. And staff has recommended to deny the applicant's request. Is there any opposition present? All right. And is the applicant present? Thank you. Mr. Schultz.
Okay, this is case 2024, 184. This is a request to rezone from R1 to RN2 residential neighborhood zone. This is a proposed use of single unit residential and townhomes. Number of acres is 6.1 acres. Number of units is 43. It's a density of 7 dwellings per acre. This will be equivalency zone map to RN16. Looking at the map, you have RN1 to the north and south and east, and R5 to the west. If you go across Jenkins Road, you do see some RTZs on that location. But primarily in this area, you'll see the new equivalency zones of RN16. There's no zoning history on this piece of property. To the north, 1808 Jenkins Road was rezoned, requested rezone from R1 to RT1. Staff recommended to deny. That case was actually withdrawn at Planning Commission. And to the west, across Jenkins Road, there was some requests to rezone to RTZ with some PUDs on those properties. This is a single family dwelling. To the north and south, east and west is single unit residential. So generally abutting this is single unit residential developments. Here's a view of the site. South of the site, single unit dwelling. East of the site, another single unit dwelling. West of the site, single unit dwelling. Here's Graham Road. You're looking down, you see all single family dwellings. This property is located in the East Brainerd Plan, which is adopted in 2020. The plan recommendation is suburban residential. Low intensity primary uses are single unit residential with some attached townhomes with limited massing up to 4 units per building, which may be located on major streets or near transit or schools. None of that's happening at this location. It's not on the major street or near transit or near school. Here's a closer view of that site. You can see it's suburban residential. Here's the site plan submitted the request. One entrance off of Graham Road. Townhomes are centered to the development of the development. Everything abutting on the exterior will be single unit detached. This request is not compatible with the Area 11 plan. It's not compatible with adjacent land use and development form. The density is higher than the density of the area. The proposed density is 7 dwelling units per acre. The adjacent density is 3.3, so it's somewhat higher. The RN16 zone will allow construction of single unit detached dwellings and attached or detached ADUs, which is more compatible with the plan goals and adjacent land uses. The RN2 at this location will introduce multi-unit residential form. So staff recommended to deny this request.
Thank you, Mr. Schultz. Any questions for staff? Mr. Anderson?
Thank you, Chair. Brian, I see R5 next to it. I'm aware that it's single family detached or single unit detached currently. And this might be a question for Karen instead. What is the equivalency zone for R5? I don't remember what we said that would be.
Looking R16.
R5? I'm asking what the equivalent of R5 is.
That's the equivalency for that.
Okay.
Detached. That's the only difference. R5 allows single wides.
Right. But we didn't make
Primarily
any distinction.
single
We allow that in the RN.
I should use my mic. I believe we amended the zone to allow single wide mobile homes with a special permit in order to make that happen.
Okay, great. Thank you.
Any other questions for staff? All right, we'll hear from the applicant.
Good afternoon, Alan Jones with Stone Creek Consulting. So I'd like to start off with this one. So if you look on Jenkins Road, the reason we looked at RN2 is that's the new equivalency for RTZ. So we were looking at kind of that mix of single family homes and introducing a few townhomes onto the site to provide a mix of housing types. I did send out about 50 letters to all the residents that live on up and down Graham Road. I did have one that reached out to me, Miss Kara Ellis, and you know, and her when I was talking to her on the phone, her opposition is just she does not. Obviously, you know, development's going to come regardless, but her comment to me was townhomes are not appropriate for this site, and looking at keeping it to single family uses only. So I started looking at, and that was the only resident that reached out to me out of those 50. I did talk to a resident who lives on Andover Circle. That's at the terminus of Graham Road, and he was actually he actually kind of liked the idea of introducing multiple housing options. But I do understand that there is some opposition to having townhomes on this road. So instead of looking at doing conditions on RN2, because RN2 basically gives you a 50-foot wide lot, but also allows you to have the introduction of townhomes. So instead of adding conditions of single family use only, because actually, if you look at if you look at the zoning case that was on Jenkins Road back in 2020, it was approved for 6 units per acre and single family detached only. That was the condition for that RTZ property on Jenkins Road, which is just there to the left on the page. So that was a condition of 6 units an acre and single family detached only, which I could put those same conditions on this one as a recommendation, but it gets back to, are we really wanting to introduce RN2 to this site, or can we look at RN15, which allows only single family homes, no conditions, and it limits the density to about 5.7 units an acre. Because from a RN16, we're looking at about 28 lots on this site with an RN15, which gives a little bit narrower lot size. It does allow it to go up to about 35 lots, which is about 7 extra lots for this property. But it would still keep it well under that 6 units an acre that was approved off of Jenkins Road. I understand this one's a little unique because it's not off Jenkins Road. It is a side street of Jenkins. But I would make the recommendation to, instead of doing conditions to limit it to single family, is to just look at having planning commission and city council consider the RN15.
Councilman Ledford.
So Alan, thank you. I'm familiar with Graham Road. It has its issues, and the city has been looking at it for years, and we actually have it on our radar, believe it or not.
That's right.
I think 2026 or late 2025, I believe. Last I talked to CDOT. We did do a study on this road, so I'm going to get ahead of, I'm sure some folks who already know this, at widening it. That was going to, at the time, come at a cost of about 1.3 million. If we were lucky, that cost has now gone north of 2 million. Last time we looked. Plus, it would take about 15 feet of everybody's front yard on Graham, which I did speak to some folks on Graham that weren't very happy about a road being on their front porch. So I think that paving it, improving the road is definitely, we have a narrow section, which long before my time was ever, I don't know how that got through, but people bought homes back there. I mean, they bought it, they go through a little narrow path, and they bought and they filled it up. So I guess build it and they will come. But it's definitely an issue with cars, buses, children. I mean, there's a lot of safety issues, and I know that we're looking at it, and we've looked at it for a couple of years. So that being said, I'm sure we will hear that again because it's a real thing. I'm going to ask that as a condition to consider improving that road in front of that entire area. And I'm hoping what that might do is stir the city to keep going with it, get it on the radar even quicker. It's something that I promise to stay on top of because it is something that needs to do, even though I may be exiting, I'll be passing that torch to whoever that needs to remain a priority.
Yeah.
So I'm going to ask that as a condition. I applaud you for getting off and away from the townhomes. I think that that is uncharacteristic of this particular, and I applaud you for at least looking at that and realizing that that is out of character for this particular case. So.
Yeah, in regards to the right-of-way improvements, there's no issues of adding that as a condition because it's going to be caught on the land disturbance permit process anyways. With a subdivision and a land disturbance permit within the city, we're going to have utility taps into this road. We're going to have to bring it up to code.
Yeah, you're going to have to bring it up to
standards. Yeah, regardless of a condition or
Yeah.
not, we're going to be doing that. Correct.
Yeah, but I want to. Yeah, but it looks better if you do that, and that, I hope that will stir. Now I know I want to hear from
Sure.
the neighbors on Graham, but this is something that I hope that will maybe, because it will go to RN16.
That's right.
And that requirement may not be actually in writing.
That's right.
CDOT may require it, it may not, but I'd rather get it in writing.
Absolutely.
Thank you.
Thank you.
Thank you. We'll hear from the opposition. As a reminder, state your name and address for the record. If you wish to speak, come on up.
Hello, my name is Donnie Ricketts, and I live at 1728 Jenkins. So my property backs up to this property, and my mother lives at 8121 Graham Road, and it runs right beside this property. So I'm very concerned about what they're going to build there and the numbers that they're going to build there. But I just ask that you remember that this is a dead end street. We already have 2 subdivisions at the end of the street, and right next to a piece of property that we also own on Graham Road, G4 is developing 12 townhouses right now. So there's going to be that going in. Right now, the dirt work is being done, and so there is a lot of traffic. The road cannot stand what they're wanting to build in there. And so I just ask that you would consider, I know it's going to be developed into something, but just not that many of them. And I appreciate your time today.
Thank you.
Hello, my name is Emily Ellis. I live at 8112, which is directly across the street to 8113. And my family has owned this property. There has been on Graham Road for around 75 plus years. And I'm here to express my objection to the proposed high density rezoning. I would like to see the townhouses go away. Both of my grandfathers actually helped build Graham Road. So it's very, it's in my blood, I have to say. So just lowering the density of the homes. I understand the growth is needed in the area, and it will help our property as well, but not at such a high density. Development is inevitable. I am concerned about the wildlife due to all of the building going on Jenkins. There has been a lot of wildlife move into those woods, and it has been such a joy to watch. But also the narrowness of the road. The Hamilton County School Bus will not go down Graham Road anymore. And this is causing children to be dropped off at the edge. I do have footage of the kids having to jump into the ditches due to high traffic. We do have speed bumps, but they aren't really helping any. So that is my concern, and thank you for your time and consideration.
Thank you.
I'm Sonny Johnson. I live at 8110 Graham Road, across the street where this construction is to take place. My biggest concern is that Graham Road is so narrow. And they're going to put all these apartments in there. And we have a school bus that won't even run up and down the road because the drivers won't drive up and down the road because they can't pass on this road. And what do you think is going to happen when they build all these apartments in there? Then they got to catch that school bus down there on Jenkins Road. And there ain't nothing down there but a freeway down on, not on Jenkins Road, just like a freeway down there. And it's dangerous for kids to get out there. By the time you get all these kids, when you build these houses and you're going to have more kids, then you're going to have a big nest down there for people to try to get on the school bus. Somebody's going to get killed or hurt. They need to, the city needs to fix the road, or the school bus can even run up and down that road now, because kids, that's a mile road, dead end road. So my concern is with the children that will be coming later on in years are to take place for their place. Thank you.
Thank you, sir. Mr. Jones.
So the original request was for the RN2, which was 43 units on this site. What we're proposing is to reduce that to the RN15, which is a reduction from 43 down to 35 lots. So it's also removing all townhomes and appearances of multifamily, that kind of thing, keeping this a single family subdivision on Graham Road. And then in addition to what Councilman Ledford had requested is having the condition that the road in front of this property would be improved as part of the land disturbance permit. And if you actually look at the frontage that this property has in this proximity to Jenkins, that's going to make a major improvement and come a long way to help the city as they look in their, what I think 2026 is its targeted date. Is that tentatively scheduled?
It's on the radar.
It's on the radar.
Yes.
This would be a great step forward in helping to maybe encourage that to come along quicker and looking at the improvements to Graham Road.
Let me say, when we widen and improve a road, you always have the desired effect of a nice, smooth, straight road. You also have the increase in speed, the increase of danger to pedestrians. It happens every single time. I want us to be real intentional and cautious when we talk about expanding or widening a straight line drag strip through a neighborhood. I think we need to be very careful. I think working with CDOT, I think starting it at your development proposal is a good place to have those conversations. And I would encourage everyone who lives on Graham Road to be part of that conversation and how it's developed, because I promise you, you will want it tore up to keep people from speeding. We did Davidson. It took almost 20 years to do Davidson Road. You heard that one earlier. And the first complaint I got was 85 miles an hour down Davidson Road, a straight shot 1 mile. That's what happens. I know it sounds great. Everybody wants a great, nice, clean path, but I am very concerned. I appreciate you, Mr. Johnson, for talking about the children, because I appreciate we create a safe path. You know what? Maybe just let off that gas a little bit, but let's not create a condition that encourages it as well. So let's be intentional on that. So I make a motion to approve RN15 with the stated condition of improving the road per CDOT standards.
We have a motion and it has been seconded. Any discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries. Next case on the agenda, item 7, case 2024-0185 is located at 1729 Gray Road, and it's an application to rezone from R1 to RN 1-3, and staff is recommended to deny the applicant's request. Is there any opposition present? Is the applicant present? Mr. Schultz?
Yes, this is case 2024-185. This is a request to rezone from R1 residential zone, which in the new equivalency mapping will be RN16 to RN13 residential neighborhood zone with conditions. Proposed use is single unit detached. This property is 10.9 acres in size. The number of units proposed is 38. That's a density of 3.4. Looking at the zoning map, everything abutting this to the north, south, east, and west is R1, which will be equivalency mapped again to RN16. The applicant provided 4 conditions: single family detached homes only, 42-foot minimum width lots is measured at the front setback within development, except any lots fronting Gray Road shall be 50 foot wide, 5,000 square foot minimum lot area, and a 10-foot wide landscape buffer planted with class 1 trees. Space 25 on center joining the north and south property boundary. Again, there's no zoning history on this property. 7529 and 7611 Ziegler Road to the west of this site did receive a PUD. This is a single unit development or detached development. To the north is single unit residential. To the south is single unit residential. And to the east and west is single unit residential. Here's a view of the site. Another view of the site. This is north of the site, single family dwelling. South of the site, you can see it's single family dwelling. This is east of the site, single family dwellings. And this is looking along Gray Road, sites on the right hand side. This property is in the East Brainerd Area 11 plan, which was adopted in 2022. The place type recommendation is suburban residential, which is primarily low intensity. Residential primary uses are single unit detached. Here's a closer view of that place type recommendation, suburban residential. Here's the site plan submitted with a request. You can see it's one curb cut or one cul-de-sac off of Gray Road into a subdivision. This request for a low small lot residential development is not compatible with Area 11 plan. Adjacent land use and development form. The RN16 zone will allow construction of single unit detached dwellings and attached or detached ADUs, which is more compatible with adjacent area and land use plan. Approving RN13 at this location will set the future precedent for future requests and introduce a small lot zone into a primarily large lot suburban residential area. Using the RN13 zone as a tool for reduced lot size and setback variances instead of applying to the Board of Appeals is more appropriate than applying for a PUD. A PUD may be a more appropriate tool here as a portion of this floodway property is located in 150-foot TVA transmission line in existing pond. So staff recommends to deny the RN13 and pursue the route of a PUD or use the existing zoning and seek variances.
Any questions for staff?
Councilman, real quick, can we go back to the self-imposed conditions just for the future? RN 135 and 7.5 and 6, they're all single family only, correct? So
That's
that
correct.
condition is not needed in the future.
That's correct.
Thank you.
Mr. Price.
Thank you, Mike Price, MAP Engineers. The request is for 38 single-family homes. Our density is 3.4 units per acre. I would point out that there's an error in the staff report that the City Council did actually approve the PUD request at 1619 Gray Road. That was done in 2023, and it had a density of 4.92 units per acre. So we are less than what was proposed just right down the road on the same side of the street. Given these facts and the density and proposed use is compatible with the Area 11 plan goals, we would pivot and ask to go to RN-1-5, which requires minimum 50-foot wide lots. And it will probably reduce the number of lots to approximately 34 single-family homes. Don't have the exact number, but I don't think that at the end of the day, that's really a condition that matters as long as single-family lots are at least 50 feet in width. So I think that would knock out conditions 1, 2, and 3. We could keep condition 4.
Mr. Anderson.
Question for staff. Correct me if I'm wrong, RN15 is not available here because it is outside the urban overlay. RN15 was designed for the urban overlay. RN16 was designed for outside the urban overlay. Am I incorrect on that?
We talked about that. No, you can have this outside the urban overlay.
Was that purely for the
For the
equivalency
equivalency mapping? Yes.
But they're available to everyone.
Yes.
Okay, thank you.
Good question.
Sure.
Yeah.
So obviously we've got this new zone and there are a lot of questions in regards to how the development community is going to use it. But it does strike me as odd that, we have an applicant asking for a zone and then we might be approving another zone. I don't feel like that's something that we do where, for example, if an applicant were to have 4 months ago applied for RTZ and then came in and said, okay, I'm not fine. We don't need RTZ. We're okay with this other zone. Would we have done that? And I'm just asking because I'm not necessarily opposed to this. I'm just wondering if.
Correct me if I'm wrong, but I think it has been happening in the past. As long as the advertisement is for something's happening on this property.
Changing the zone.
Yeah.
We have done it in the past, but now we'll have a track record of planning commission recommendation heading to council to be able to share with applicants. When perhaps they ask for an RN13, we'll be able to share some of the conversation that's been held at planning commission to give a little guidance.
So if anything, we might expect even more of that kind of thing.
I would say less in the sense that we can share that, the comments on the RN13 or the RN2, for example. I think that's what we share with applicants during the kind of that pre-submittal process. And now we're going to start to have a track record to say that, what might be a better alternative instead.
Okay. Thank you. Did we have any opposition here? Okay. What's the will of the commission?
So I'm going to, Mike, thank you. I feel like you've been paying attention this afternoon and somehow looked into my head, which is scary. I am going to add another condition, if I may put the onus on you to also increase or improve the road in front of this development to obviously in conjunction with CDOT standards, as we did with the PUD late last year, this will help stir the city to make improvements, although we also want to be intentional about public safety. So condition 1, the planting of the trees along the northern perimeter, 20 feet of center from Gray Road to the TVA easement stands. And then I think the second condition, if I may add, if you're in agreement, Gray Road to be widened and the right-of-way dedicated to the city of Chattanooga as determined by CDOT.
In agreement, I would just point out that the tree spacings are at 25 feet on center, not 20.
I will be happy to oblige at 25 feet on center, and the motion is for RN15.
We have a motion, and it has been seconded. Any discussion? All in favor, say aye. Any opposed? Motion carries. Mr. Price, I just want to ask one question. Historically, if you were doing a development and the road needed improvement, would you have made improvements to bring the entire road up to city standards or just your side of the road?
Typically, it is just our side of the road. That being said, there are certain instances when developers are required to do the entire road over certain lengths. So it's almost a case by case basis, but generally it's limited to do just the frontage. But
So when we add that condition, what do you think happens in LDO when you go to get the permit? Are you then required to improve the opposite side of the road?
No, sir. I think that the way that, as I understood it, we would need to dedicate right of way, which typically the city attorney's office has been a little loath to require that. But now that this is a condition that if it passes at city council, we would be required to do that, which means the widening simply occurs all on our side. So,
where that runs into a problem is if that road is, say, 17 feet wide and it needs to come to 22 feet wide, does all 5 feet of that widening happen on one side of the road?
no, sir. Typically what happens is we set the road to be at the proper width at the time it would be widened by the city or some other entity in the future, so it lines up. What you don't want to have is some sort of weird offset that would create a weird jog and be unsafe to the traveling public. So instead, what we do is widen it out as if we were widening out both sides equally coming down through there.
Okay.
Great
Just
question.
making sure everybody was on the same page when we're adding that as a condition.
Yeah, thank you. Great points. Thank you very much.
Next case on the agenda, item 8, is case 2024-0191, and this is located at 2315, 17, and 2401 Glass Street, and it's an application rezone from R2 to CTMU, and staff is recommended to approve. Is there any opposition present?
Motion to approve.
Motion to approve, and it has been properly seconded. Any discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries. Next case on the agenda is case 2024-0192, and this is located at 2659 Glass Street, and it's an application to rezone from R1 to CTMU, and staff is recommended to deny the applicant's request. Is there any opposition present? All right. The applicant's present. Mr. Schultz.
Sure. This is case 2024-192. This is a request to rezone from R1 residential zone to CTMU, transitional mixed-use commercial zone. Proposed use is mixed use. It's 0.14 acres in size. Proposing 4 units above the commercial. It's a density of 28.5. Looking at the adjacent zoning, this will be an equivalency zone map to RN15. To the north, south, east, and west would be RN15. So there is no CTMU in this general vicinity. This is a little different than the site right before this, which we staff recommend to approve. There's been no recent zoning history on this site. In 2024, the case just acted on was a request to go to CTMU. The 2714 Glass Street to the southeast of this site was rezoned from R1 to RTZ with conditions in 2023. It's a vacant piece of property. To the north, east, and west and south is single unit residential. North of the site, here's a view of the single unit dwelling. This is south of the site, again, single unit dwelling. This is the site itself. This is east of the site, which is a single family dwelling. This is west of the site, which is a single family dwelling. This is located in the historic River to Ridge Plan, Area 3, which is adopted in 2020. The place type recommendation is urban residential, which is neighborhood retail services and offices are listed as secondary uses. Non-residential uses should have limited impacts on residential character of the neighborhood. But it's primarily urban residential or single-family dwellings. Here's a closer view of that property. Again, it's urban residential. Here's a site plan submitted with the request. This request would not be compatible with adopted historic River to Ridge Plan. It would not be compatible with adjacent land uses, as adjacent land uses are all single-family. This would introduce commercial on the bottom floor at this location. Again, this will be equivalency mapped to RN15. The development in this area is largely urban, residential, single unit detached. The request for CTMU zone this location would introduce non-residential uses into this primarily residential neighborhood. Again, we're currently undertaking a land use plan for the city of Chattanooga. Staff recommends the applicant consider a rezoning application in the future once the plans are adopted, so they can provide more guidance about land use changes at this location to introduce commercial. So staff recommendation was to deny this request for CTMU at this location.
Any questions for staff? Mr. Payne?
Yep, just refresh me. You recommend denial, but you want him to
if he wants to withdraw the case, he can come back after the plans are adopted to apply, depending on what that plan recommends.
Okay.
The plan may recommend commercial. I don't know. It doesn't.
But if we deny, how long till he can bring it?
It's a city council, 12 months. He may withdraw before that or make it approved.
Any other questions? All right.
Thank you, Commissioners. My name is Michael Kenner. I live at 114 Evening Side Drive. I am the developer of the previous lot that was mentioned that just passed, and the developer of this lot as well. Just a little history around the community engagement with this. We hosted a charrette. That was a 3-part charrette series. We have facilitated approximately 80 members of the community coming out and giving input. For those of you that don't know or aren't familiar with Glass Street is approximately 8 blocks total. 5 of those blocks are heavily zoned commercial. The last 3 blocks are not. A lot of the input that had come out of our community engagement during our charrette process was that the community felt that Glass Street should be commercial the entirety of its row to help spread the economic development needed to revitalize that community. What we are proposing is not 4 units over retail. Unfortunately, we want to propose 1 live work unit over retail, but with the new zoning code that is in play now, you can't get a single live work unit over a retail component that's actually true retail or even a coffee shop component, because actual retail is not allowed within live work under the new plan. So we were kind of left with going to the CTMU in order to achieve what we were trying to achieve, which is 1 single live work townhome on the site. We think that live work townhomes are going to be the first thing to help revitalize this community, because you get eyes on the street 24/7 with retail, and someone living above that retail aspect and component. And like I said, the whole entirety of the community, including 3 neighborhood meetings we've had with the Glass Farms community as well, and all of that, it's kind of been agreed upon that everyone wants this whole strip to be commercial from the whole entirety of the 8 blocks. So.
Thank you. There's one individual here, maybe with some questions or in opposition.
Bill Tim, I own 2657 Glass Street. I also own the other 3 units to the left of that. If we could put up, I think, that original picture of yes. So I own the 4 units to the left of the red indicated lot, and I also own 2626 Andrews, which backs up to that. It's the L-shaped lot over on the left corner. So I have 5 properties that connect to this 1 property. I've spoken to my tenants who all had to work at this time and were unable to attend. But they encouraged me to pass along the feedback that we all discuss and their concerns. I wanted to start by saying I was unaware, and my tenants were unaware of any of, I'm not sure what he called it, but a community meeting I would have gladly attended I was completely unaware of it, and none of my tenants were aware of it either. He also made reference to the previous case. I think I heard that passed. Personally, in the years that I've owned these properties, there's a considerable difference about the area where it just passed and this area. I believe, as staff or whomever indicates, this is a cluster of residential, where those other ones were, if I understand where it is, it's full-blown commercial. As a matter of fact, one of the concerns I'll discuss is safety, and the crime that I'm aware of tends to stem from that more commercial area down the street where those others just passed. And we oppose bringing similar zoning that seems to have crime associated with it and putting it right on our side door. My opposition includes infrastructure, parking, safety, peaceful and quiet enjoyment, property and rent values. Infrastructure. I would like to know how what I would call a skyscraper is going to access the sewer. I call it a skyscraper. I believe the staff's data indicated a change in height. My dwellings are all 1-story, 8-foot ceilings, sit on a foundation, I'm guessing, of 3 cinder blocks, maybe 4. So a structure that goes up 45 feet is going to make a statement, a negative in my opinion and my tenants' opinions. Parking. Existing infrastructure and capacity cannot support the significant increase in traffic and parking needs, creating problems for current residents. Insufficient parking on the lot and the street for tenants, friends, owners of this commercial space, customers of this commercial space, and employees of this commercial space. The site plan even indicates 7 spots for parking, which I don't think you can see the bubbles on that, but in the bubble, mine actually has something in the upper right, mentions 7 spots, but when I count on my drawing, I don't even think they could fit the 7 in the drawing. I see 6 drawn, 7 mentioned. Overflow. The only place for overflow would be on the sidewalk, in my tenant's driveway, or the private alley that I own that this property adjoins in the upper left corner where that vehicle is parked. Lack of parking has already forced me to put no trespassing signs up in an attempt to reduce parking on my private property for people that don't live there. Safety. The site plan appears to have inadequate setbacks for corner lots, hindering the ability to see when turning on and off Glass Street. I don't know those setbacks, and I assume the planning folks have reviewed it, but years ago when I met with people and talked about corner lots, there were significant setbacks on corner lots. They told me for visibility reasons. Traffic and parking congestion from 4 residential units and commercial space, which would add 5 to 10 vehicles for residential and countless for commercial, filling up the parking lot and streets with people coming in and going in and out, going all day. Potential issues from trespassing since infrastructure cannot support parking and traffic. My units have families with small children, many of them several children, and they have concerns for their safety and their children's safety. As I mentioned, the majority of crime that I'm aware of
on this street stems from the area down Glass Street, which is much more full-blown commercial, which is being proposed to sit right next door to my tenants. Peaceful and quiet enjoyment. Concerns having too many people that the infrastructure cannot support. Business operating early, late into the evening, 6 p.m., 8 p.m., 10 p.m., traffic blocking parking, sidewalks, noise, smells, issues. It's a commercial space. No one knows what's going to occupy that space. Conflicts with overflow of tenants and customers blocking access. Since there's nowhere to park for these people, my tenant's driveway is right next to it. Skyscraper 40 feet high next to single family dwelling 1-story houses, excessive noise, lighting coming from that massive structure. Property and rent values. In my opinion, putting high traffic commercial space and a massive building with 4 rental units above will overcrowd existing infrastructure, leading to less desirable space, harder to place families in my rentals, and bringing down the values. I appreciate y'all listening to some of these concerns. I don't think this type of building belongs here. I think the rules and the stuff that was read earlier is a clear indication that we're adding something that it's not currently zoned for. It's going to be very out of place. If you think with 4 rental units, if each unit has 2 or 3 cars associated with it, let's call it 8 vehicles for those. There's only 6 spots drawn. That doesn't include the owner of the property that's going to visit. That doesn't include the employees, 1 or 2 employees that work that shop. We're up to 10, 13 cars now. That doesn't include the customers going in and out of this commercial space where my tenants and their families and their small children wake up and go to school every day and come home and want to relax. I hope y'all I hope we stick with what I understand the staff recommendation be to this is out of place and it's not a good fit for this area. Is there any questions for me?
Any questions? Yes. Okay. I don't hear any. Thank you.
Thank you.
Go ahead, Mr. Bird.
First of all, I want to commend you for showing up on behalf of your tenants to a 3.5-hour meeting. That's incredible. I very much appreciate that. Trying to think of the best place to start here. I guess speaking from personal experience, I just want to make a few points, especially about rents and desirability of this sort of unit. I live next to a unit. I'm in a single family home, you know, pretty typical for a neighborhood like this. And I sit right next to a building that's 2.5 stories tall. It's got a brewery in the bottom, a record shop up top, and a barber shop in the middle. And it was actually a major selling point for me moving to the area. There is a cadre of people who this sort of development will not only not lower property values, it'll actually raise property values because this is desirable to certain people. It's not a foregone conclusion either way, is what I'm trying to get across. You know, depending on what businesses go in, it certainly could lower them, but there's an equal opportunity for it to raise property values. I take issue with calling a 3-story building a skyscraper. That's just a personal opinion. I do think you make some good points about the infrastructure and about the types of units that'll be here, parking demand, you know, how people are going to get around. It, again, depends on what sorts of people are going to be looking at these units. I know I personally rode my bike to this meeting. I know Mr. Kenner rode his bike to this meeting because I saw his bike outside. There are people who can get away with having 1 car, no cars, and they're moving to areas like Glass Street where there is a significant amount of commercial development within a walkable, bikeable distance. Again, it's not a foregone conclusion either way, but it does happen. I do have a question for Mr. Kenner, actually. You mentioned the community charrette. Do you have kind of an outline of what happened? Any slides you can share, survey results, anything like that that could sort of provide some numbers or some drawings, or even just people putting stickers on maps saying, hey, I want commercial further up Glass Street? Because this is pretty far from the Glass Street commercial district.
We did email, and I don't know if you guys have access to that, but we did SWOT analysis, and we emailed a map with results of that to the planning department. I've got 240 acres I'm rezoning total in this area, so these are the first two of many that will come before this body, but the SWOT analysis kind of encompasses all the work around all of those different ones. I don't know, do you guys have that by chance, or Dan?
I know we do have it. You've emailed it to us, so yeah, we do have a copy of it via electronic.
Okay.
So I'll just say my personal inclination right now is to ask for a deferral for 30 days so we can review that information. But I'm not going to make a motion right now. I'll yield to the floor.
One question I have is oftentimes the neighbors and planning commission can get distracted by a site plan. That site plan currently shows 6 parking spots, but what we're ultimately doing is not approving a site plan. We're approving or potentially being asked to approve a zone. Do y'all know what the parking requirement would be if this was built? Is 6 right?
Depends on what it is, what the use of the property is. I don't know.
The way it's been described, it's a commercial unit on the bottom, and then
Live work is 1 dwelling per unit. Above ground is 1.5 per dwelling unit. Commercial depends on what it is. So I don't know. Because again, we don't do the site plans for parking. But
Sure.
yeah, I don't know off the top of my head. Depends on what type of commercial it is, because there's
And
different
then
ranges here.
I don't think the commercial and residential can share, or they can share, but they still have to each meet their own parking requirement, right?
Right.
So 6 is probably not the right answer, or you think it
As
is?
residential, it would be 2, and the live work is under 1,000 square feet, so there's an exemption if it's a restaurant or if it's an office space. There's exemptions for minimum amount of square footage, I do believe, in the parking regs as well. I think we're required to do 3 by right with that size building. If we did a townhouse with 600 square feet of commercial and then 2 600 square foot single family residence, so it's all one resident. It's just commercial on the first floor, 2 stories residential above. So.
Okay. Mr. Payne? No, sir. Sorry. We do have a proper order to things. Yeah. Mr. Payne?
Mr.
I
Chairman.
just was asking about I think there was a comment that he couldn't do a single live work unit. Is that?
Well, I'm a little confused because I think the applicants now, are you saying townhomes?
Yes, one single townhome. Remember, we sat there and
The
we looked at
townhome is not allowed in the CTMU zone.
sorry. It is a commercial building that is built to look like a townhome.
So you have commercial on the bottom and it's a live work above it.
We don't allow that.
You do.
We do allow that.
Above ground floor dwelling is permitted in CTMU.
Was that what you were after?
CTMU does not allow retail, does it? Or coffee shop use?
It should. Retail goods.
So if I wanted a coffee shop in there, or if I wanted,
That's the C part is the commercial mixed use, commercial mixed use.
that's so CNT. If you look at it in your new zoning,
You're not CNT.
or CNU. CNU allows for retail uses, but it's capped at 25 feet. CNT allows for a 3-story mixed-use building, but it does not allow specifically for a retail purpose like a coffee shop or a bookstore, or it's only like office. It's very, if you actually look through the designations in those codes, you can see that we could not do like a coffee shop on the first floor of a live work building.
He's correct on CNT, but your request is a CTMU.
CTMU is what we requested. Yeah.
Yeah, I think what you're asking, you're good for. CNT would not allow that.
Yes. CNT doesn't allow it. CNU doesn't allow it. unfortunately. So we had to go CTMU, sorry.
Mr. Payne, has your question been answered?
Nope. Maybe it probably was, but I don't know. I'm not sure I understood it.
The request, to be clear, there's several different commercial zones. You have a CNT, not asking for that. There's a CN zone, not asking for that.
Yeah.
The request is for CTMU, which
But
is
my
commercial
understanding-
mixed use. So you can do, in the CTMU, you can do live work or above ground floor. You've got commercial on the bottom, you can do residential dwelling above.
Single.
Yes.
And this is what you want, a single unit?
Yes.
That's why it's going CTMU.
So it's one residential unit stacked over one commercial unit.
Yes.
So I'm sorry, but maybe I'm not the only one confused, but I heard something about, maybe it was the opposition that mentioned something about 4 units.
Well, I said that because the application says 4 units. It says 4 residential
Okay.
units. They proposed density of 28. There's 4 units above 1,800 square feet of commercial on
But
the application.
Okay, sorry.
but you're only wanting one
Just one.
unit above one commercial unit.
That's all I want.
Okay. And no,
So I'm going to offer my motion now to defer 30 days. And in that 30 days, I'd like to see some more of the, whatever you sent to RPA, I'd like to see that distributed so that we can take a look at it. And then hopefully we can also clarify this conversation right here, because we'll be here another hour if we keep this up.
we have a motion to defer, and it has been properly seconded, and that was for 30 days. And is there any discussion on that? All in favor, say aye. Aye. Any opposed? Motion carries. You'll be able to speak next month, sir. You're welcome to come back. All right, we have a number of government mandatory referrals, and this is items 1 through 10 on our agenda. They all have staff recommendation to approve. Is there any opposition to any of those? Okay, thank you. So we'll move quickly through them. So just make sure that, so I'll ask if there's any opposition in regards to a specific case. Make sure you raise your hand because I'll be looking for you. Item 1 is M2024-0173 as a staff recommendation to approve. Is there any opposition present?
That's 2400 block of Ridgecrest Drive.
You're here in opposition? Yes. To the first item there?
Yes, it's actually to the first 5 items.
Okay, thank you. Mr. Schultz.
Do you want me to go through just, the city is actually acquiring these properties. I don't know how you want to handle this one at a time, or what's the easiest for you all?
Why don't you?
They're different locations, but they're all the same. The first 5 are acquisitions of private property, then the other 5 are surplusing public property.
Right, okay.
I don't know which is the best way to do this.
Why don't we hear from opposition
Okay.
first, and then if there are any questions for staff, we'll cover those. Ma'am, state your name and address for the record.
Megan Hall, 433 Cherokee Boulevard. I've lived in Chattanooga for 25 years. I think it's the best city in the world. I don't plan on ever living anywhere else. I had a relative that fought for the Union Army in the 4th West Virginia, which was part of Light Burns Brigade, which is part of the Battle of Missionary Ridge. I was looking at these 5 parcels, and I see they're all owned by the Trust for Public Land, I think. And I'm not mad at free land. Don't get me wrong. My issue is all 5 of these parcels have significant historical value to the Battle of Missionary Ridge. I think they would be better used by the, as part of the Park Service with the parks that we already have. 2 of the parcels are like right next to Sherman Reservation, which is owned by the Parks Department. And Those two are on Moon Street, which if you've ever driven on Moon Street, I can tell you now the city of Chattanooga is not maintaining that road. So I don't feel like they're going to maintain those parcels. I feel like it makes no sense for them to own these two random parcels on the street. All five of these, one of them, the Ridgecrest one, it's like a 9-acre parcel. And I understand there's restrictive covenants, but it also allows for things like, I think environmental testing was one of the things allowed. I just want to make sure that these sites remain undeveloped, and I think they would be better served as part of the park system than by the city of Chattanooga.
Mr. Chairman, I can give you a brief. This would apply to all 10 of these as a summary of the request. Basically, what the opposition is saying is a property acquisition of one of 5 properties that will Trust for Public Land will donate to the Parks and Outdoors for designation as urban preserved sites. There will be a declaration of restrictive covenants on the parcels that will ensure the protection and stewardship of these parcels. Efforts will be made to protect and manage significant natural resources through stewardship and best practice managements that do not degrade the resources present. Additionally, these sites may be used for conservation and environmental research. So that's what they're doing the swapping for. Is the city is acquiring 5 properties from Trust for Public Land, and the city is also giving up 5 more, giving us back to Trust for Public Land, all in the name of this urban preserve sites. Now we have somebody from, I think could probably speak more to these.
Mr. Payne.
Yeah, I just have the question. You're advocating for them giving it to
The Park Service would make more sense.
which part? Are you talking about the federal?
Yes.
Okay.
So it'd be part of the Chickamauga Chattanooga National Military Park would make more sense because it's literally up against them.
Yeah.
I don't know that we can just give property to the federal government. That is,
They'd have to want it. They'd have to want it.
Yeah, again, I was going to say dealing with the federal government is a lot.
I think that would be congressional action. I don't want to speak out of line, but I'm pretty sure that the government can.
I think what is trying
And
to
if you
happen.
think we're inefficient here, see how that goes.
I mean, I think with the trust for public land is kind of they acquire properties and they try not to hold them long term. They do want to give them to government. And then once they're in local government, yeah, you do want to put some kind of easement on it just to make sure government doesn't do something with it. And I think that's the intention.
Yeah. And if I may, Chairman, I'll add to what Dan says. You didn't read it in the narrative, Brian, but I think it's important. The first sentence says the Trust for Public Lands has owned these 5 vacant parcels since 2005 and prefers not to be the long-term property owner. There's actually a agreement to transfer them to the City of Chattanooga Parks and Outdoors to designate it and covenant and provide appropriate stewardship. So it sounds like obviously a mutual partnership agreement.
Mr. Chairman.
Mr. Lyle.
Thank you, Mr. Chairman. I'm just wondering, typically before we hear from opposition, we typically hear from the applicant.
Well, in this case, I just went backwards because I was having a hard time imagining why anybody would be in opposition to this. So I thought it'd be helpful if we heard from opposition first. So we wanted to hear comments like that so that then we could better ask questions to staff. So I thought we would do this one in reverse. We'd hear from all the opposition, and then Planning Commission could direct questions to staff to try to get a better understanding of how to address those concerns.
And I think the question of maintaining, vacant property by the city is a great, question of how it's going to be maintained. I think having Parks and Outdoors, whoever's going to be aware, I'm sure they'd like to maintain them very well. I think it's the reason we're here today is because I think this is an important issue. So I think that's the intention.
Well, ma'am, can you come back up to the microphone? So can you state your concern? Because I do think you requesting that these not go to the city of Chattanooga and instead go to the National Park Service is probably not something that we can entertain.
I understand.
But can you be really specific about your concern? Because we
Sure.
started to hear it while you were sitting there.
Specifically parcels 75 and 77, they're right next to each other. and they're both on Moon Street. If you've ever driven Moon Street,
It's starting at 186.
it's so skinny you can't get two cars past each other. There's potholes that would eat a car up there. You've got two blind curves there. The city's not like the entire road. The city, it's just like they've forgotten about it. So to have two vacant parcels on a road, the city does nothing to. Like when a limb falls, the residents there are the ones that go and get it off the road. The city doesn't go up there. So I just have concerns that that land will just fall into disrepair and we'll have more history lost there because the city isn't maintaining it currently, the area around it.
Thank you.
Mr. Chairman, let me clarify. I misspoke. It's not all 10. It's actually the first 5. This acquisition, I misspoke. It should be 6 through 10 is for surplus of property for public affordable housing.
And I don't know if this first 5 is urgent this month. I mean, maybe it's something that we can get some more information from Parks and Outdoors, and if you all want to hold on to it for a month.
Yeah.
Just drive across Moon Street and then think about it.
Thank you, ma'am.
Just to clarify, this is about giving land from Chattanooga to Trust Republic.
No, other way.
Backwards, other way.
Trust for public land is given to the city.
The first 5 are coming to the city. The next 5 are city disposing of property for affordable housing.
Trust for public land.
Trust for public land.
The area is fine. It's just, the city area around it.
And I'll say the applicant will have to ask for a deferral. You as a planning commission need to get the applicant to defer because if not acted on with this body within 30 days are deemed approved.
Or we can deny it.
Yes, and he still goes on to city council for their action.
Or approve it. So if you're here in opposition to 1 through 5, are you here in opposition for one of those?
I wouldn't say opposition, but.
Sure.
All
State
right.
your name and address for us.
My name is Panya Dixon. I am here on behalf of my father, or with my father, Walter Edwards, sitting there at 2706 Grove Street. So his property at home sits across or adjacent to the properties. And so we just had some concerns because we just didn't know exactly what's happening or going to go on with the property. So my dad has been the owner of his property for 48 years. 48 years. And like the young lady stated, the road has never really been maintained like that. So our concerns was if it's going to be a park, a preservation, or open to the public like that, how is that affected? So the question is, what are the plans? Is there a long-term plan, or do you all have plans for this property? What exactly are those plans? I know it's a preservation. Is it going to turn into a park? Is it going to be something that's developed, open to the public? Things like that. So we just, with my father being there, and his house again sits right there, right at that property. We just didn't know exactly what the plans are. And if it's going to be a park, what type of park is it going to be? Those type of questions. And when will the development begin? Those type of questions.
So I think, again, we don't have any information about any proposed development. I'm assuming it's going to remain pretty natural. But when this gets to council, I mean, obviously Parks and Outdoor needs to be there and provide a whole lot more information to council.
All right. So I just want to make sure there's
why is Parks and Outdoor not here today?
Good question.
Who's the applicant? Okay.
Back there.
All right. Yes, come on up.
Erica Robinson, City of Chattanooga, Real Property 101, East 11th, Suite G18. And then as far as the property goes, as of right now, we're responsible for filing the application for that acquisition. So as of right now, we don't know the definite plans from Parks and Outdoors as to what's going to take place. From our understanding right now, of course, they're placing that declaration of restrictive covenants and changing it to an urban ecology preserve. So it looks as if they're going to just be preserving that area and not, like I said, I'm not 100% if they're going to develop or anything. I can't say.
That is a problem we have with mandatory referrals. We get very little information that comes to this body. It's hard for us to
I don't.
make decisions.
Mr. Anderson.
I would say, yes, I would defer it. And then we can, if we need to, get the proper person to come in and explain, I guess, a little bit more. But from, like I said, what I understand, it's being preserved as an urban preserve for just essentially preserving that land so that nobody develops on it. But yes, I will ask for a 30-day deferral.
So we do have a motion to defer for 30 days, and it has been properly seconded. I want to have some discussion around that so that, and really that's just in regards to the first case. So we'll need to rattle through these real quick if we're going to do that on the first 5. But I do want to have some discussion so that it's really clear what the expectation is between now and what happens in 30 days. Mr. Anderson, you wanted to make a comment, and then I want to make sure to have some discussion around what's supposed to happen in the next 30 days.
I think Parks and Outdoors probably thought this was a fairly routine exercise. Most people don't have a problem when we want to acquire land to keep it green and not developed. I have nothing to do with this project, but I will say that the head of Parks and Outdoors, Scott Martin, would prefer that we have everything as preserved green space in the entire city, and never is in favor of developing property. So, and he's calling Councilman Ledford right now. So I have a hunch that this will never be developed, and they're trying to preserve it. And that is the point. I've never seen opposition to preserving land in an area, but if it's the will of the commission to defer 30 days, I'm sure we can get him here next month, but he's also going to appear at council next month if we approve it today.
So the request of Planning Commission would be that in the next 30 days, the Parks and Outdoor and the city of Chattanooga do the same thing that we expect developers to do, which is to hold a neighborhood meeting. I don't understand why it's a different expectation. I don't think it should be. And I know this isn't you with the request, but if this were a developer coming in with, you know, an intent to, we saw the same thing with the stormwater tanks that were needing to be built, where the city of Chattanooga kept coming with these mandatory referrals and the community showing up with questions and concerns, and they haven't held the neighborhood meetings. So the request is that in the next 30 days, the city hold some neighborhood meetings and bring everybody up to speed in regards to what's happening on these 5 cases. Is that fair?
Chairman, I can't speak to what specific meetings have been held or not because I'm not a part of Parks and Outdoors meetings. Scott loves a good neighborhood meeting, so I know that he's held them all over the city for various things. But I would just disagree with you that this is the same as a developer, because it's literally the opposite of that. It is literally preserving it for no development,
Well,
not even a water tank.
I only meant in the same way that yellow signs are going up, people are here and they know nothing about what the intent. So these folks have sat through 3
That's fair.
hours and 49
I mean,
minutes.
it's fair. It could be a park of some type, and it would have parking and things.
Well, and they may have an opinion that would be of value to the city to have heard from the residents. What needs to happen for sure is that somewhere on some piece of paper, all of you who showed up need to write your names, your phone numbers, and your email addresses, so that 100%, as Planning Commission, we can hold the city accountable to having at least made contact with all of you between now and the next Planning Commission meeting. So, and then if any of you want to speak, you're welcome to go ahead and speak. I don't want to cut you off. You have sat here for almost 4 hours.
I don't want to take too much time. I would just ask, case 4, it's an individual lot. It's at top of West Side Drive where it hits Southcrest. I bought 5 acres on West Side Drive, right beside it. Those 3 acres, that lot, you can't access it. If you guys know the top of West Side Drive in Southcrest, it's a ravine. It has access to the East Lake Park behind it. To my understanding from the neighborhood, they've talked about bringing a path up that property to hit Southcrest, it would be directly beside my brand new house and building to be my primary residence. I have talked with Trust for Public Land people. I've talked with Scott Martin. There's intent, I think, to build a path. Not now, but in the future. And once they get the property, I'm just deadly concerned that it's going to be a problem. The other problem is that property you cannot access it. You only access is from my property beside it. And so they're going to get this property that they can't keep up. And it's been a dumping ground for years that I'm actively cleaning. I just bought the property 3 years ago, still building my house. It'll be cleaned up, but terrified the city's going to get it, and then it's just going to.
Mr. Lyle.
Name and address for the record.
Louis Zebold, 3123 West Side Drive.
Mr. Chair, if everyone puts their name and information, we'll share that with both real property and with Parks and Open Space. Just note the concerns and have the contact information.
Thank you. Ma'am.
Hello, I'm Blake Wright, and I own 3013 West Side Drive. That's my primary residence, but I also own 3023 West Side Drive and 5 lots behind my house. So I'm specifically here about the item number 4, 3100 West Side Drive that Louis just spoke about. I actually would request that that deferral not happen because I'm here due to Louis having opposition to it. He's overstating the community conversation. He actually showed up to the Missionary Ridge Neighborhood Association saying there was going to be a trail and this is what this meeting's about, and trying to get community opposition against the trail by fear mongering, saying people from the bottom are going to come up. So it's actually, I have some residents of West Side and I've talked to Southcrest members, and we are highly in favor of preserving this land. It needs to be preserved. It is located, as he said, on an incline. And Louis actually cleared 3 lots that he purchased at the top, which ruins the integrity of Missionary Ridge. And so we are trying to prevent that from further happening. So anyway, I'm just going to pass it on because there's some people who have lived on the street longer than the 8 years I've been on, and Louis hasn't actually lived in the property at all.
Edward Hewitt at 3011 West Side Drive. I was present at the meeting that Louis came to speak his opposition to the Missionary Ridge Neighborhood Association. And he frankly stated that he does not intend to live at the house that he's built on West Side Drive, and he might possibly build a second house further back in the woods. So I don't know why he's got anything to say with this, since he doesn't actually live there and doesn't intend to live at his property. I am in full support of this and full support of preserving all and any green spaces. Thank you very much and have a wonderful day.
Thank you.
Kim Flowers, 3018 West Side Drive. And I'm just here trying to preserve the integrity of Missionary Ridge.
Thank you, sir.
Hello, my name is Linda Carter. I'm from the Historic District of Chattanooga. I stay at 1710 Vine Street. We have the residents calling me concerning something we received a proposal on 2 weeks ago about the 200 block of Oak Street, and that the city is mandating the surplus. And also they're going to turn it into affordable housing. Affordable housing can mean a lot of things. We worked hard for our R1 zoning. So we're gonna make sure if you're going to put affordable housing in that block, that we do maintain our R1 zoning. We have too much, that corner has a whole lot of traffic. It has a whole lot of wrecks. And right now we have lack of parking in the Chattanooga area. So we don't need any more multiple dwellings or so-called affordable housing. This is going to be single-family housing for families.
Thank you, ma'am.
Mr. Chairman, I think she was.
That was in regards to item 9 on.
Yeah, that's being surplus to Chambers Children's Homes for overflow parking. We're not changing the zoning.
Okay. All right. So on items 1 through 5, we have a motion in regards to the first one anyways, and all 5 to defer for 30 days. And we're having discussion on that. That was seconded. Is there any further discussion on that?
Chairman, if you don't mind, I actually did speak with Scott Martin a moment ago, and the intent of all of this is to preserve, period.
Mr. Chairman.
Mr. Lyle.
I had the opportunity, years are flying by at this point, so I can't say exactly which year it was, but to sit on the Parks and Outdoors Master Planning Committee with Mr. Martin and others, laying out the roadmap for the future of the parks system, the first time that that's been done in more than 100 years. The town, and I would implicitly trust what it is that Scott intends on doing with that property. For that reason, I'm going to vote no on the deferral. I would say we just move forward with this and dispose of the property, get it in Scott's hands, and allow the city to move forward implementing an incredible master plan that puts world-class parks in everybody's easily accessible backyards.
I don't disagree with you at all, but
I also agree with you that
to have had a meeting
yes.
with the community so that they didn't have to sit here through a 4-hour meeting.
I agree wholeheartedly.
And Scott may not have known that, or somebody from the city didn't know that, but they didn't know what was happening to the property. Mr. Anderson.
I also intend to vote no on the deferral. This is to preserve property around a historic site. There's no reason to delay that. I believe the delay is unnecessary, especially in light of the fact that it will go to City Council a month from now, where Scott Martin and the Department of Parks and Outdoors will present at that point. I think the delay is unnecessary. I plan to vote no.
Ma'am, we're going to. So we do have a motion, and it was seconded. We've had plenty of discussion on it. All in favor of the motion, say aye. Any opposed? No. All right, so we'll just run down, and somebody keep count, because I won't. Well, I will. Mr. Payne?
No.
Okay, motion fails.
Chairman, I make a motion to approve.
Second. We have a motion to approve, and it was properly seconded. What? We're voting on case 1. But once we know how this body is going to rule on one, we should be able to move through the rest, assuming nobody has a different opinion on some other one than we did on the previous one. So we have a motion to approve. Did I get a second? Okay. Any discussion? All in favor, say aye.
Aye.
Any opposed? Was, if you voted no on the previous one, did you just vote yes on this one?
Yes. I did.
Okay. Did anybody change their vote? Okay. Any opposed? All right, that was unanimous. Motion carries. So on item 2 on the agenda, mandatory referral 2024-0174. What's the will of the commission?
Motion to approve.
Second. We have a motion to approve, and it has been seconded. Any discussion? All in favor, say aye. Aye. Any opposed? Motion carries. On case 3, mandatory referral 2024-0175. What's the will of the commission?
Motion to approve.
Second. We have a motion to approve, and it has been seconded. Any discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries. Item 4, mandatory referral 2024-0176. What's the will of the commission?
Motion to approve.
We have a motion to approve, and it has been seconded. Any discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries. Item 5, mandatory referral 2024-0177. What's the will of the commission?
Motion to approve.
We have a motion to approve, and it has been seconded. Any discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries. Item 6, mandatory referral 2024-0186. Is there any opposition present? Move to approve. We have a motion to approve, and it has been seconded. Any discussion? All in favor say aye. Aye. Any opposed? Motion carries. On mandatory referral 2024-0187, which is 7 on our agenda. What's the will of the commission?
Motion to approve. Second.
We have a motion to approve, and it has been seconded. Any discussion? All in favor say aye. Aye. Any opposed? Motion carries. On item 8, mandatory referral 2024-0188. Is a staff recommendation to approve. What's the will of the commission?
Motion to approve. Second.
We have a motion to approve, and it has been seconded. Any discussion? All in favor say aye.
Aye.
Any opposed? Motion carries. Item 9, mandatory referral 2024-0189.
Motion to approve.
We have a motion to approve, and it has been seconded. Any discussion? All in favor say aye. Any opposed? Motion carries. Mandatory referral 2024-0190.
Motion to approve.
We have a motion to approve, and it has been seconded. Any discussion? All in favor say aye.
Aye.
Who's opposed? All right, motion carries.
Mr. Chairman, just for the future, we'll try to anticipate when there could be on such a large number of mandatory referrals that we should have just somebody here representing them or something. I apologize. We didn't anticipate that. I assumed, like y'all, that it would be very smooth.
Well, I just want to say it's a super legitimate concern when you live in the city and the city has assets that are not being maintained, and you've got neighbors picking trash up off of the streets and so on and so forth, and then the city's now taking the property. And so, I think you are our city representative on Planning Commission, and I hope that, on behalf of those residents that have concerns about how the city manages its property, that the city does a good job of managing these, and keeping
Some
them
of it
clean.
sounds like condition of streets and things like that, which if you've been up on Missionary Ridge, they're absolutely, but this is a challenge for us, as we'll talk about more in our citywide plan. We need to have money to maintain roads.
I think that's right. And Chairman, all the concerns have been heard today. Me pushing them forward was not recognizing those concerns, just saying that this is not what that is about. This is actually to preserve the land as it is, and TPL no longer wants to own it.
Mr. Lowe.
Thank you, Mr. Chairman. Yeah, I think the piece that I just want to underscore again is that in this instance, I feel like my expectation of myself as a practitioner rezoning a piece of property, or any number of the developers that come through here asking for properties to change hands, that community engagement work is critical, because the public does just want to know what is the intention. And I feel like that was a piece that was missing that we can learn from.
Thank you. All right. We have some resolution amendments. And I will not be reading ordinance numbers or the exact resolution, but I will then just reference the agenda. So on item 1 on our agenda, which is the first item under resolution and amendments, is there any opposition present? We have a motion to approve, and it has been seconded. Is there any discussion? All in favor say aye.
Aye.
Any opposed? Motion carries. Item 2 under resolutions and amendments. Is there any opposition present? We have a motion to approve, and it has been seconded. Any discussion? All in favor say aye.
Aye.
Any opposed? Motion carries. On item 3 under resolutions and amendments, is there any opposition present?
Second.
We have a motion to approve, and it has been seconded. Any discussion? All in favor say aye.
Aye.
Any opposed? Motion carries. Item 4, is there any opposition present? Are you here? Ma'am, you're sitting here. I'm concerned that you're in opposition to something. And Please.
Sorry. Are we talking about resolution amendments for to adopt the official zoning map?
Yes.
Okay.
Yes.
Do you want to talk first? No.
Mr. Chair, I have a brief presentation.
Yes, please.
Thank you. Brian's connecting it. And we do have Phil Noblet here, the city attorney, who has been supporting us throughout the process. As you know, adopting a new zoning ordinance and a new official zoning map is a pretty big deal. So just have a few slides to go through. Brian, if you can just click through and I'll try to move quickly. This is just to go back one. I know you all know this, but just to say that Brian, Emily, Darian, Lee, and I have been working on this for diligently, but without the four of them, we certainly would not be anywhere near where we are today. So just a thanks to them. So the new zoning map will transition property from the old zone to the new zoning regulations. We're intending to apply the most similar zoning category to property to the zone that's currently in place. The intent is to allow properties as much as possible to retain their current uses. As you know, there are protections under state law and in the zoning ordinance for businesses as they need to expand. And so on the webpage, we do spend a little bit of time calling out those protections. So activity to date, we developed a website. This is one of the main methods of communication. On that website, there's also a map that shows the old and new zoning. We had about 2,000 hits on the map and 1,700 hits to the story map. You could do click one and then the other. So but just to kind of show activity, we documented equivalencies there in a table in front of you. And let me hand one to Phil while I'm at it. And so the equivalency table is really where we're showing what the transition is. So we're not talking about one individual property. We're talking about a zone. That zone may have conditions that may be inside the urban overlay or outside the urban overlay, but that equivalency is what we are talking about through this transition period. We held a District 2 meeting. We had a District 4 open house. We presented at Friends of Hickson. Presented a City of Chattanooga neighborhood leadership meeting. We provided outreach to development stakeholders, been to a couple of public meetings or neighborhood meetings. We have a District 9 open house coming up. So if you've been on the webpage, there's several things developed. You can get to it most easily through this website. And we'll talk about going to that. This tells the whole story about what we're doing. We really try to make it simple for folks. Learn what it is about the process, check your current and proposed new zone, review the frequently asked questions that we have an R1 handout on R1 zoning, and then contact staff. And that's what we've been doing quite a bit, is talking to folks about the proposed equivalency zone for their property. So what we're doing today is adopting an official or recommending to approve an official new zoning map for the city of Chattanooga. Next. So the digital file is what we're adopting. It's developed through this link. It's finalized 11/15. We were without a internet much of last week. So the 11/15 was the date last posted to have the last few properties cleaned up. It's incorporated in by reference. So I wanted to point out the PC resolution. So the resolution that is going with the adoption of the map lays out several important things. It notes that this is the map identified in the zoning ordinance, the official map. Conditions carry over. That was a lot of the discussion with folks that had questions about equivalency. Just a reminder that conditions are carrying over. So the adoption of the new map has all the cases with that conditional language as part of it. It does include special exceptions permits, including PUDs. So we did use the process to get rid of old abandoned PUDs that have been sitting on the map that we didn't have a tool to get rid of, but the updated map does do that, including, for instance, institutional. Now an institutional zone might have been an R1 institutional PUD previously, but that's all noted in the documentation. It doesn't impact the form-based code. So the official adoption of the official zoning map has no interaction with the form-based code. It's just carrying that base map over. The resolution does say 1108. We're asking to update that 1115 as part of the resolution. And when city council acts on the new zoning map, that will repeal and archive essentially the old zoning map. We did make a commitment that we would document that one place clearly so it's available for reference in the future. So that's something we're working on. Also, just an aside, we have one zoning case out there. We've closed out every single other case. It's intending that if there's something that's been sitting and deferred indefinitely or tabled at council, those are being closed out through this process. So we have one case that's still out there, and just noting that. The equivalency table as shown does include the conditions. So as part of the process to get the most equivalent zone, we are taking advantage of the ability to add conditions. We do not want to do that, but we have some, for instance, the RTZ, where to get the most equivalent zone, we really needed to add on a few conditions. And if you remember, there was a period of time where there were modifications approved by Planning Commission for about a year. We did phase that out several years ago, but just noting that those carry over to the ordinance that phases out in 2022 had language basically saying, although we're phasing out the process, those were still valid actions. So next. So the equivalency table, you do have a copy of that. The date on it, just to be clear, and what we're acting on here is 11/14/2024 at 3:35 p.m. It's been a lot of copies of this, but just that's the one that we're asking Planning Commission to act on. And again, this is not about what is that one individual property. It's what are those zones look like. Next. So there are two things that we got asked end of the day. Alan Jones would be one person Friday, which was great. Alan's been great in identifying and then helping us check some to make sure we've got some stuff right. He did flag something in the R4 special zone. If you look at the equivalency table, R4, I mentioned last month, R4, UGC, C3 are they're so broad. We had to do a lot of parsing. So just asking, if Planning Commission chooses to move this forward, just note that we're going to check the R4 equivalency. Kind of the difficulty of that is R4 used to allow multifamily. Some of the equivalent zones do not. And so we just need to give that a check. And thank you, Alan, for bringing that up. And then one more, next page. Fort Wood, which is R4, primarily R4, got picked up with the institutional zone change for UTC. So we're just going to equivalency map that as shown on the table, but it didn't get picked up on the map, and Lee flagged that this morning that we needed to just give a correction. So those are two items. The Fort Wood map will get changed. We would probably need to identify the change for that R4 zone to council at council. So outside the equivalency map, we do have, so part of the communication next was, of course, we have this one outlying property, just to let you know it's out there. And then we do have 3 properties that are identified as in talking to people. The first 2 properties on the list were slated to be CMU1. The requested zone was TRN3. And that is really based on what was proposed to be used. Moving from a C3, the TRN3 zone was more appropriate because it is a lower intensity zone than what is proposed to the equivalent zone. Because the TRN3 zone is surrounding these or nearby these properties, staff's recommending they change to the requested zone. So this is an outlier. These are 3 outliers from the equivalency table. The third one is a request. Someone, when she became aware, Susan Lookout Valley, became aware of what her checked her zoning, I guess, and became aware of the conditions, asked to lift conditions. So this is not intending to be the process, but there were only 3, and the request is to amend her conditions to limit her uses. And so that seemed reasonable to accommodate during this process because it is more restrictive. And so staff is recommending approval of the zoning map as shown. We're going to correct that Fort Wood, and then these would go, staff is recommending move to the requested zone because they are more restrictive. And then well, we can handle that next. So are there any questions about the zoning map? I do want to, there was a note about I wanted to make a note that we do know we need to look at heights as part of this, just playing with the numbers and spending a lot more time working with it. We'll probably come back to you all in December, maybe tweaking some of the heights. And just also noted last Tuesday at council, council extended the grace period. So right now we have an effective date, assuming Planning Commission acts today. The effective date of the zoning ordinance is 12/18, assuming council acts on the 17th. The zoning map and the zoning ordinance are slated to be effective December 18th, and then we have a 6-month grace period, which puts us out to June. So during that grace period, someone can use their old zone or their new zone. They just need to convey when they pull a building permit that they're using their old zone. And that's all I have, Mr. Chair, unless you have any questions or unless Phil wants to say anything.
Are there any questions, Karen? Mr. Byrd?
For existing non-conforming uses, were those in this map put in their use zone or in their legal zone?
So there is language in the zoning ordinance, I believe, about that, and I cannot. There is something in there about if you were non-conforming when you moved into it, but I can't bring it up right now. And then there's also, so we're not looking at everyone's specific use because again, we can't look at every single property in the city. So we're looking at the allowable uses in the zone, but there are some protections under state law that we have put in that talks about extension of non-conforming commercial uses.
So you took the underlying zone and equivalency map to that, not look for every single use and say, hey, that's an existing non-conforming use. We're going to put it in a zone where it is now conforming.
That is correct,
Okay.
because that's beyond our scope, and because obviously uses change.
I mean, and it's a lot of.
Yeah, I will say where it picked up was with institutional uses for the R4 special zone owned by institutions. I'm looking at I'm sorry, I didn't put a page number. It's the top of, I guess, the 4th page. Because private senior living facilities did not have a home in the new zoning ordinance based on what their old zoning was, we looked at those uses. Because so if we had a couple uses, for instance, we had, let me see, we had another example of where we ended up, funeral homes. We couldn't find a good place for them. So we amended the zoning ordinance. That was a planning commission last month to find a place for them. So we did look at a few uses that we really did not have a home, but that is not universal across the city.
Thank you.
But just as a reminder, the new zoning ordinance has a broader category like retail goods, which before it might have been, we had things like fish shop. There was like really specific. And so hopefully that broader category has helped with that.
Or a cat clinic only?
Cat clinic only, still a condition that's sitting out there on your favorite property.
It is.
Not anymore. Now would be a good time.
I think that's the only use of that
Well,
property.
we do like cats. Let's just be clear.
But now would be a good time.
Just saying. Are there any other questions on item 4 under resolution amendments? Any opposition? Yes, come on up.
This is like so specific. But I know that there was a couple residents in Battery Heights when we learned about the zoning that were interested in preserving their neighborhood that didn't map to the equivalency. And I know that they reached out, and I'm just curious what happened with that information for those properties. And if this impacts that decision, or will they still be able to like go and they reached out to the input form online?
It's not ringing a bell, but we'll double check it. But they wanted a different zone than they were
They
equivalency
wanted
map
the
for.
RN 175. I explained what I learned, which is if you're really in opposition to it, that you need to like write with your tax number, and they said that they had done that, and I just didn't see it here. And my question, I guess, is this?
You're getting some blank looks. We'll have to double check it. So that's not on our radar. Okay.
Well, this will not mean that they cannot still.
No, we'll look for the email, and if I don't see it, I'll contact you.
Okay, and then going forward, will other residents be able to?
So the RN 7.5, 6, and 5 were set by council during the process. And so we are using the guidance set by council, but we can flag that and if people can let us
I
know.
just want to advocate for
Sure.
They left earlier.
Yeah, thank you very much. Yes, I'll follow up with you then.
Mr. Anderson.
Just Ms. Benavente, just so you know, and the rest of the commission knows, the RN1 7.5 was only intended for the Henderson overlay between Signal and Lookout Mountain. And that is what we called it.
That's what we call
it. For lack of anyone coming up with a better name for it. So there's nothing preventing a lot from being 7,500 square feet or 5 acres or whatever it is, but what is now R1 in that area is RN16. The only difference is the minimum lot size.
Has not been adopted yet, though, right? The code has been adopted, but the equivalency map has not been adopted. That's what we're about to adopt right now.
That's correct, but since the code has been adopted, the code states that for that part of town, the new R1 is RN16. That is the equivalent. So there's no ability to have RN175 there. It was only for the equivalency mapping for that overlay in District 1. But that said, there's functionally no difference because there's not going to be any other RN17. This would matter if it was new development, but there's no difference for an existing property.
Okay. It might be because it's 5:30, but I'm no longer exactly tracking these levels.
We can
of detail.
follow up and share. There's a map in the zoning ordinance that shows where 7.5 is applied to.
Yeah, no, I understand where it's applied to. I saw intentional. I think that it's just there was people that were like, I would prefer to have that on the equivalency map for my property, and they were something that we by saying this person. Thanks. Sorry. Thanks. You can follow up.
Yeah.
I guess it is possible to come back in and request it.
Rezoning.
Yeah.
We
I don't know how
had
you do
specific
that, but I would
parameters
think
set
about
on
that.
that.
All right. Any other discussion on item 4? I'd entertain a motion.
Move to approve.
Second. We have a motion to approve and it has been properly seconded. Any discussion? All in favor, say aye. Aye. Any opposed? Motion carries. To staff, maybe Karen, I think it would be helpful as you have a planning commission that has historically worked within the same zones for some of us 10 years and now working in a new zone. If you had bound and printed copies of the new zone here at Planning Commission that you could collect after Planning Commission. Because I think what you're going to see happening at future meetings are a lot of questions for staff in regards to these new zones from Planning Commission. Because, all of these professionals have been working inside of one set of zones and these are new to us and we're not as accustomed to them. And I think it would make it easier on y'all if you are not the only ones with a copy.
We will do that. And then also we've got 2 amendments. So at some point that will all go into Municode, but yes, we can do that. And also we talked about now that we're kind of at this phase, we need to switch to focusing on outreach and handouts and one pagers about like, what does the TCMU zone mean? And so we will have copies for the next meeting.
That'd be great. Next item on our agenda is item 5 under resolutions and amendments. Karen, did you want to speak to that?
Just briefly, and this is similar to last month where I said as we started to use the ordinance and look at the equivalencies, we identified some things. We have protected zones that got missed. And this is using the equivalent zones from the prior protected zones for the form-based code. Children's homes was identified as a couple people. We've actually been having some discussion about a children's home, so we're just making sure we've got that clear. One of the things that came up during the process is the C3 Central Business Zone did not require parking. And so the new zones do. We don't have that zone because C3 didn't require parking, but it kind of came with this 13 or 15 standard conditions. So there's a new language in there that exemptions and reductions from required parking is if you were zone C3 prior to the changeover, and there are not many, right? Most of C3 got replaced by the form-based code. We just have a few properties kind of hanging out on the edges for the most part. You're not required to add parking. The intention is to not all of a sudden put parking standards on properties that haven't had it. And then last, we did, as part of the process, notice, and I think that it was probably my mistake, the TRN3, the townhouse width had changed, excuse me, the single unit width had changed from 40, it was 40, but it had been 25 in the past, so we're just correcting that to 25.
Thank you. Any questions for staff?
Move to approve.
We have a motion to approve, and it has been properly seconded. Any discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries. Staff updates.
So I had planned a very in-depth presentation, but I'd like to just say both the city and the county planning documents as a draft are almost entirely, there's a couple little things that we're still waiting on, but almost entirely online now as draft documents at planhamilton.org and planchattanooga.org. We will be bringing Plan Hamilton to the Planning Commission next month. We're still having some public meetings, and we've resolved many issues that were sort of hanging out there from the last series of public meetings. I would just quote Marvin Gaye and say, please believe half of what you hear and none of what you see and half of what you hear. The plan, I'll just say for the county, I think, to be clear, a lot of what we have done is to try to put into a policy things that are the current practice. We have identified, for example, $130 million worth of improvements to roads in the county, but we are absolutely under the knowledge that the county doesn't at the moment have $130 million to go through with this. We are hoping through this planning process is to create a document and a process by which we help the county budget those kinds of improvements over time. And so my point is these plans are absolutely intended to help build infrastructure and help the county and the city respond to growth. And so I'm just going to not have more to say today, but just say next month you'll be enjoying getting to review the documents.
It's fantastic. Thank you, Dan.
Promise we'll enjoy it.
Yes.
Do any of the funding strategies for Hamilton County include buying lottery tickets? Because 130 million is just not that much money, is it, Todd?
I mean,
okay.
The county budgeted 5.8 million this year, so
okay,
that's
a far cry from 130 million. We do have a time on the agenda for public comments on non-agenda items. Are there any? Yes.
Thank you, commissioners. I would just like some clarification from the commission around form-based code, if possible. If you guys could bring up the PDF for form-based code for me.
I can't bring that up, but I can tell you what you're going to talk about. I got right here.
Okay, there's currently there's an A, B, and C reference for, and I apologize, my phone literally just died before I came up here.
I can read them off if you want me to real quick.
Pulled up. Yes, could you read off the A, B, and C?
What he's talking about is form-based code boundary expansions for large sites that are 40 acres plus. You can ask for an expansion like the form-based code did for Wheeling Foundry, the Bend, and Chestnut Street. There's criteria in the code that says when you can do that and when you cannot do it. Here's for non-abutting properties, expansion of form-based codes. The property is within close proximity to form-based code boundary.
That's A, right?
That's A, or one here. The physical character of the property is consistent with the overall character of the nearest form-based code context area. That's 2. Number 3, the property is included in the adopted downtown plans. Very specific what plan that is. So there's 3 criteria. Mr. McKenna, what's your name?
Michael Kenner.
Submitted an application for form-based code. Well, it's 5 miles from the nearest form-based code boundary. The other 3 were either abutting or immediately like a half a mile from downtown. Existing form-based code boundaries. All 3 of those properties were included in the downtown plan. Mr. Kenner's property was located in the Eastdale plan. So we did not accept that application based on these 3 criteria to move it forward.
But my clarification to the body is this. It seems like there's an A criteria, which is you must be abutting. There's a B criteria, and the C criteria is that you must be above 40 acres. When it was written initially, there was only one plan in Chattanooga, and that was the downtown plan, I do believe. So there weren't community plans to adopt anything larger than 40 acres into. The reason why I ask is because I had the unique pleasure of taking Peter Katz out, the guy who wrote the form-based code college and initiative, and who also has been very involved here. We also wrote the Congress of New Urbanism. CNU is the people that created form-based code. Form-based code was created specifically for large infill and urban development sites. So a site over 40 acres that's within the urban core of Chattanooga should be able to write its own form-based code according to those regulations under C.
And I will say too, just to add some clarity, the 3 previous form-based codes, we didn't have a new zoning code. We now have a new zoning code. It has all ranges of uses, new zones. So when those were written, we didn't have that. You know, form-based code was our closest thing, and they did meet that. So I'm not sure. I think he's asking potentially to amend this section.
I'm asking us to look into it because although my time might have passed on my large site, if there's any other 40-acre sites where you could apply form-based code, and specific example of this is if I want to do a 3-story mixed-use building and then I want to do a cottage courtyard community right next to that 3-story mixed-use building, there is no zoning code that you guys currently have that allows me to do that unless I go for PUD. If I try to do a PUD over a 200-acre site, that's a 15-year development in multiple phases, and that PUD moves a building by more than 10 feet, I have to come back, I do believe, through planning commission, but for sure back through council, anytime I want to move a single building. So this is a systematic issue within the code that I would love to see addressed, whether it's at this point in time or not. I just wanted to bring it up to the body. Don't know what we can do about it, but.
Mr. Anderson.
I'll be quick. Michael, I had the honor of being a part of the team that wrote form-based code 10 years ago. And we got a couple of people on RPA staff who were on staff at the time too. It's only 10 years old. There were lots of other plans besides the downtown plan all over the city, just to make you aware. There were plans all over the city, way older than 10 years old. I don't think the intent at any time was for it to be that far out. You know, the existing infrastructure on Broad Street is not the same as the infrastructure on Glass. And I think that was a part of what was taken into consideration. But I'd be happy to work with you after this meeting to help figure out a solution for your issue without adopting a downtown code in a suburban area.
Okay. All right. Thank you.
Can I make a comment and ask a couple questions real quick? First of all, we're referencing the downtown plan, which is hopefully about to be superseded by, I guess that would be the Area 4 plan, I think. Number doesn't matter. Is that going to be an automatic update to that
We'll have to go back in and amend it.
We'll have to go back and amend it. Okay. And then what would be the process if somebody wanted to amend those 3 criteria? Who would that have to originate with?
Just like the applicant would come to this body requesting
Chris, Commissioner Anderson, are you raising your hand as a representative of the city or as a commissioner?
I think if we're proposing, I think it would come from the administration. It originates with Planning Commission for action, but Planning Commission doesn't write it.
Right.
So
I mean,
if your
none
question
of
is
us
where
here
it
would write
originated,
it, but
would be
if
internal.
somebody were here at this meeting to make a motion to study it, would that be valid?
Sure.
Okay. And then one last comment before I wrap up real quick is I don't want to conflate form-based code and downtown zoning. I don't think those are necessarily the same thing. I don't think they have to be the same thing. There's many form-based codes throughout the country that are not downtown specific. Seaside bears no resemblance to our downtown, but it's a form-based code and it's all 2-3-story buildings. So there's a lot of ways to mesh those two and to take the infrastructure into account. So I don't want to rule that out entirely. Thank you.
Do you want to say anything else?
No, I'm good.
Thank you. All right. I'd entertain a motion to approve the Planning Commission minutes of October 14, 2024. We have a motion second. Any discussion on this? All in favor, say aye. Aye. Any opposed? Motion carries. Mr. Payne. Thank you, Mr. Payne.